Good afternoon. The Senate Finance Committee is in session. And I want initially just to state the order of the bills for this afternoon, and then we'll get started with our first one. We have Senate Bill 131, Senator Patterson. Senate Bill 191, Senator Patterson. Senator 47, Senator Corderman. Senate Bill 138, who is that? Senator Heddleman. Senate Bill 275, and who is that? Senator Hester. Senate Bill 158, Senator Lee. Senate Bill 194, Senator Benson. And Senate Bill 9 will wind us up for the afternoon, Senator Kramer. We will, in each case, begin with the senator who is the lead sponsor, and then we will go to those people who have been selected. Under the pandemic rules, we have a maximum of 4 persons who can testify in favor of the bill, other than for the sponsor. And then we will move to those who are unfavorables or those who just are providing information. For Senator Corderman's Bill 47, we will start with him, and then the person who gets. Oh, I'm sorry. Okay. All right. We're going to start with Senator Patterson, Senate Bill 131. Okay. And so, Senator, you have as much time as you need to introduce your bill, and then your one affirmative person has 5 minutes. Thank you.
Thank you, Madam Chair and Mr. Vice Chair and committee members. I believe this might be my first round coming before the Finance Committee. So I do appreciate the opportunity to be here to introduce Senate Bill 131. Just finished 121. Senate Bill 131 seeks to ensure through perhaps technical correction that the Apprenticeship and Training Council designate Black and Latino individuals on the council, which makes up about 41% of the Maryland population, is that again, Black and Latino. The Maryland Apprenticeship and Training Law and Regulations established what we consider a 12-member body called the Maryland Apprenticeship and Training Council, MATC. The council formulates apprenticeship program policies, standards, agreements, and in addition, there are 2 additional members that are consultants who also bring some support and expertise to the committee. So I don't have a long introduction, Madam Chair, but we believe this is just probably almost an oversight that these minority groups was not established in the legislation. And we would hope that this committee will think that as many of those in my district, and I think throughout the state, that the time has come to be a little bit more sensitive about being inclusive. And this is just one more step to get us to that position. And with that, Madam Chair, I do ask for a favorable response. And I am pleased and happy to have as my lead and perhaps my only witness, Mr. William Bill Taylor, who has been long champion in this area. And he, along with some of his co-workers, brought this oversight to me. And thus you have before you today, Senate Bill 131. Thank you very much.
Thank you. Before we go to Mr. Taylor, are there any questions for the sponsor? All right, if not, then Mr. Taylor, you have 5 minutes.
Committee Chair, how are you? How's everyone today? Good afternoon, ladies and gentlemen, and members of the Finance Committee. My name is William Taylor of Fort Washington, Maryland. I am the past chair of the Maryland Apprenticeship and Training Council, where I served for 14 years. My purpose here today is in support of Bill 131 that should include representatives that are Black, Latino, female, and individuals with disabilities. In addition, consultants to the council should include representatives by Black, Latino, female, and individuals with disabilities. This will help ensure that the Maryland Apprenticeship and Training Council will have diversity in gender and race in its sponsored programs. The Maryland Apprenticeship and Training Council has a deep commitment to ensure that there is balanced representation in employment opportunities. I am an advocate for opportunities that will support diversity in the workplace and allow all individuals to become productive and contributing members of our community. I applaud the enhanced focus on Bill 131 to include diversity on the Maryland Apprenticeship and Training Council. A more diverse council will help with recruiting and increasing diversity of skilled workers statewide. We cannot afford to lose the sight of diversity at this critical time. Again, I ask you to take the necessary action to ensure that the Maryland Apprenticeship and Training Council include representatives of Black, Latino, females, and persons with disability. Also, consultants to the council should include representatives of Black, Latinos, females, and individuals with disabilities. Thank you for the opportunity to address this committee.
Thank you very much. Are there any questions from committee members? Senator Hershey. Senator Hershey?
Thank you, Madam Chair. Yeah, just a quick question for the bill sponsor. And I know there's no opposition to the bill, but have we ever been this specific in other councils and commissions? Again, I see the normal diversity type language that's in there for the makeup of the committee, but this gets very specific. Have we done this before? And I mean, could this end up becoming so prescriptive that this is considered discriminatory?
I don't think so, sir.
Go ahead, Mr. Taylor.
We'll allow the sponsor to try to answer.
Not really. The bill in part already designates some portion of the population.
Right.
Omission, and we just wanted to make sure we have a total inclusion.
I understand that, but I'm just wondering, does it become so prescriptive? And that's why I'm asking, have we done this in any other councils or commissions?
Well, I can assure you that during the summer months, fall, I was a part of the President Senate work group, and we looked at all components. We looked at procurement, we looked at lack of individuals specifically on boards and commissions. And I would say that I don't believe that we are setting a precedent here that would cause us any harm. I think rather I would like to look at it as a means of ensuring that everybody have a seat at the table.
Yeah, I understand that. like I said, I just wanted to make sure we weren't going down a slippery slope. Again, I know there's no opposition and I'm not certainly opposing it, just asking the question for that knowledge.
Right.
Okay, thank you, Madam Chair.
Okay, are there any other questions? All right, if not, thanks so much. And that ends the testimony on Senate Bill 131.
Oh, that's a lot.
We're going next to Senate Bill 191. Senator Patterson, Labor and Employment Hiring Higher Education Requirements Give Me a Chance Act. Your
Yes,
5-minute witness is Christopher Dews, and then we have some others, and we'll call them in order.
Thank you, Madam Chair and committee members again. Senate Bill 131 is 191 is a model similar to that of Senate Bill 738 that we filed in 2019. But more specifically, this bill will prevent employers from relying on the wage history of an applicant until after an offer of employment has been made. Senate Bill 191 restrict employers from denying an applicant on the sole basis of the lack of a college degree. I have two very expert witnesses, Madam Chair, that probably know more about this than I will ever, but I do believe that it's time to look and take a holistic approach and looking at all these impediments that might be a chance for those who've been left out of the system so long to find their way back. And in my county, I know we are missing out on good tax dollars because we have not made that extra special step to ensure that we look at those individuals who have limited skills such that they cannot get into the job market such that we can get taxes and they can buy homes and those kind of things and keep our county employees in the state and in the county. So with that, I'm going to ask that we move to Christopher Dews and Kimberly Armstrong, who has been the champion on this piece of legislation. And I will admit, I think I got quite a stack of letters from others throughout the state, but we believe that this is a good bill and we hope that you will give it full consideration and passing this bill out favorable. Thank you.
Okay, so your 5-minute witness, the person it assigned initially is Christopher Dews.
That is me. All right. First of all, you guys can hear me, correct?
Yes.
Beautiful. Okay. My name is Christopher Dews, and I'm a policy advocate for the Job Opportunities Task Force. Our mission at JOTF is simply to help lower wage workers advance to higher wage jobs. And as such, we support Senate Bill 191 as a means of ensuring that qualified working applicants are not denied access to employment on the basis of a biased credentialing standard. Just to be clear, the state of Maryland is ranked number 2 right now in the nation for the most well-educated or basically degree-holding citizens in the country. Number 2, right after Massachusetts. However, even though we're number 2, only 40%, not even 40%, 38% of adults over the age of 25 in the state of Maryland, working adults, have a college degree. That means roughly 60% of our working adults do not have a college degree as of right now. And this, of course, can become a problem. What we're seeing, at least with our constituents and the workers that we're working with right now, is that people are trying to apply for jobs, and because they don't have a college degree, their application is not even being considered. And so what we want from this legislation is for a person's experience to be considered first before you jump to throwing the person out for credentialing. This is specifically an issue with older workers who may have just been in the field for 20 to 30 years and now find themselves, because of the economy, because of the pandemic, or even dating back to the 2009 housing crisis where the economy fell there as well, they have to look for work, or they're looking for new jobs, and they're finding themselves unable to be able to invest or even be considered for employment because they don't have a degree. And many of these positions are in service. Many of these positions may be in management. They may find themselves not qualified simply because they don't have a degree for a position that they may even be experienced for. I'm a person who has a background in the arts, and when you're in the arts, it's really just about your merit, your ability, and your talent. So, for example, nobody's going to say if you're Van Halen, oh, I'm not going to have you perform for me because you don't have a degree in music or something like that. I know that seems like an arbitrary standard, but the idea is rooted in experience. What is a person actually able to do? I was in workforce for 3 years at a nonprofit, and the number one concern I would always hear from employers was, can the person do the work? That's the number one thing they would ask me about. They didn't ask where they were from, how much they used to make, or whatever. The number one concern was, can they do the work? And our concern is that if a person's application is thrown out simply for the lack of a credential, then you're going to have a very qualified pool of applicants that are just tossed aside. And I just want to drop some numbers really quickly. So according to a 2019 study, the average student loan debt within the state of Maryland was $32,000. The national average is actually $29,000, which means that the state of Maryland actually ranks higher on the national average. And that 2019 number of 32,000 is roughly an 8% increase year over year compared to the 2018 number. So what we're seeing is that there are more and more people coming out of college with a ton of student loan debt and have a lack of access, or not a lack of access, forgive me, a lack of economic opportunity to bring that number down. And so in converse to that statement, to dodge student loan debt, we're seeing more and more workers go into the trades, more and more workers get themselves educated without having to go to college at all. What we want is for the worker who gets himself educated or gets themselves trained without having to, spend hundreds of thousands of dollars on a 4-year education. What we want for that worker is that they will not be denied when they are in the application process. I do want to say one quick thing before I wrap up my testimony, and that is that the bill does not stop an applicant from discussing their collegiate experience. That's very important. You can start the conversation by saying, I went to Harvard. The bill also does not prevent a position that requires a specific license, like a Juris Doctorate or, electrician certification from being considered. So, and it does not also, I want to be very clear about this, it does not also force employers to hire non-college graduates. All this bill simply does is allow for an applicant to be considered, and if their experience, if their skills, their trades, their talents is enough to do the position, that the employer should consider that before throwing out their application altogether simply because they don't have a specific credential. And for those reasons, JOTF, we urge a favorable report. Thank you for your time.
Okay. Are there any questions? Senator Augustine?
Thank you, Madam Chair. And thank you to the sponsor. And, but I just have to say that, education obviously is something that is so important. I know it's been preached in my family, and that it actually is a great leveler. And it's been a way out for so many folks. And it's just such a critical thing. My concern, or what I would ask you all, is have you thought about the opposite implication, which is a person who hasn't done those things, gotten those degrees and everything else, might be given a position because of who they know or something like that. And then therefore it actually discounts the work that a credential that a person has put in, which may open doors that otherwise are closed because those jobs, those positions are going to people who don't have those credentials. I just would ask if you've thought about that.
I can let the senator answer first, and then I'll answer, or however you want to do it.
Yeah, I definitely asked.
Well, you're talking now, so.
That's fine.
I'm sorry. Okay, I'll start. I'll just say, first of all, Senator Augustine, thank you for the question. And I actually want to say that I'm in agreement with that situation. The issue that I have with that line of reasoning, first of all, it's very real, right? That if I have a college degree in a specific field and I am not getting a position compared to somebody who does not have a degree, that of course has its inverse impact. My problem with the kind of undergirding assumption in that principle is that's how do I say this properly? That is already happening. I want to be clear. There's a lot of racial aspects to this. As a person who has spent a lot of time in the film industry, there's been plenty of times that I've seen an 18-year-old who, just because his dad was a radio host or his dad was connected to whatever, that they're getting opportunities that a person who went to, let's say, Towson for cinematography for 4 years are not. The dad may own, for example, I don't know, 2U Studios out in Virginia or something to that effect. So I guess what I'm saying is, to the point of this bill, that is a different conversation, because what we're seeing is that let's say that take that same 18-year-old kid who is just as talented and may have the ability, but that same 18-year-old kid, because he does not have a high school diploma, does not have the connections, won't even be considered for that position. So okay. I understand. Sorry. Forgive me if I'm talking too.
Let me follow up.
Okay.
You see in the preamble to the bill that this has an except under certain circumstances. Would
Yes.
you, not both, but or the sponsor explain what the certain circumstances are? Because there are jobs that absolutely require a college education. So when it is applicable, so tell us where in the bill to go to see the exception. And I think that's really what members are asking about. We understand there are many jobs that a person can do very without a college degree. There are other jobs that absolutely require that, and I assume that's in that under other circumstances. So where in the bill should we take a look?
So, sorry, I apologize. Should I answer that, Chairwoman, or?
Well, either of you,
Please.
just one or the other.
All right. So in my understanding of the legislation, this bill, of course, like I said before, does not does not prevent employers from asking for a credential when it comes to positions that specifically require that credential. Now, the question is, where is that specifically at in the bill? I don't, in my understanding, don't believe that that is necessarily fully spelled out. Like it doesn't say, for example, if you have a degree, if it's a cybersecurity position, that you have to have a degree in cybersecurity. It doesn't say specifically if it's, I don't know, a publicist that you have to have a degree.
So you're saying you don't know, you like the bill philosophically, but you haven't looked at every single bracketed area. So let me ask the sponsor, is there a recognition somewhere in this bill that there are some jobs that absolutely require college education, and that if you need that credential, you're not telling people to ignore that or to waste people's time?
Madam Chair, I don't have the exact page on, but in the bill, it talks about special exception, and that would make reference to lawyer, doctors, those persons that everyone would want to ensure had the credentials to have and hold that type of position. We are not talking about taking those individuals out of the system. If I'm a cardiac patient, I want to make sure I get to a cardiologist, so to speak. So,
and I believe you, and that's why I was asking the question.
yeah,
You
right.
might want to work with the analysts or try to get yourself in a
Okay,
to clarify that.
all right.
So that,
Madam Chairwoman, if I
I
can.
don't want to take this bill to the floor and have a problem on the floor, have you lose. I think your intent,
Mhm.
but that exception is referenced as an exception, but it doesn't say what the exception is in the preamble. And then you're telling me that there is a paragraph here somewhere that
Yes,
references that,
yes,
but
Madam
it
Chairwoman,
doesn't
it is-
clarify.
forgive me, it is page 2 of the piece of legislation, line 23. Forgive me, my legalese is not as strong as the members of the committee, but I want to say it's under section A, subparagraph 2. And that's where it simply says that if a minimal education qualification is necessary to perform the duties of the position, that is subject, that is the subject of the application or interview process. So that is allowed in those
And
types of
that, I think you're answering what I've asked you, and I think that's a little shaky.
All right.
Indeed.
A lot of people would still do what it is you want them to stop doing. That is to ignore people who do have sufficient credentials for what they are applying for, but who then get asked about a college education that isn't a necessary credential. So I think this might require some kind of an amendment or enhancement to make sure that we don't have people take time on the floor if the bill gets that far to asking that same question. So you might.
Madam Chair, we'll be happy to do that.
Okay. All right, we're going next to Kimberly Armstrong.
Good afternoon, Madam Chair and committee. I'm Kimberly Armstrong, and I am in favor of this bill for the simple fact that I think it has not just a great title, but sometimes people just need a chance. And just because someone hasn't gone to college doesn't mean they have not been educated. I am a great proponent and a big proponent of higher education as well. So I'll just use my own personal experience. I didn't have an opportunity to go to college until I was 44. Why? Because life happened. I had children at a young age. I had disabled parents that I had to take care of. I always wanted to go to college, but just never had the opportunity. However, I had a wealth of life experience and work experience. And a lot of times when I would apply for jobs, because I didn't have a college education, I would not even get the opportunity to at least perform and show what I could do. And just to address the comment that I think Senator Augustine, talked about is people who may know people may get a position. Nepotism. Nepotism is alive and well, and it is not going anywhere. So I've seen people who, and this is just my personal opinion and also my personal experience. I've seen people who have higher degrees that may not be as efficient or as qualified for a position as someone who may not have a degree. So I think just giving someone an opportunity and a chance to just show what they can do will also allow them to be better when they have an opportunity or if they consider to continue their higher education, which happened in my case. I didn't go to college until I was 44 because my children were older. I didn't have to get a babysitter, and a lot of other things played in the factor. Now I have a degree, which also between my life experience and now my degree has qualified me to be in a management position. So, I just want to thank you all for having me to at least bring my personal experience and my professional experience. I've also have worked with Mr. Dews in the past at another nonprofit where people just are like, just give me a chance to let me show you what it is that I can do so that I can have that opportunity. And I think that also sets up better for us economically as a whole, as a just life, not just life experience, but in economics. You put more people into the economy that that pay taxes. They have an opportunity to buy a house or get their own apartment, things of that nature. So they become valuable citizens and, become productive people in our community. And I think just giving people a chance to show what it is they can do,
Okay.
and also allow them the opportunity to further their education if they choose to.
Thank you very much.
Thank you.
Very much. Mr. Sponsor, your other person doesn't appear to be in the room. So I hope you will work on the amendment before we vote on the bill so that we clarify and not have problems with it on the floor.
Thank you very much, and we'll follow through, Madam Chair.
Okay. All right. We're going now to Senate Bill 47, Senator Corderman.
Yes, and thank you, Madam Chair. And before we get started, I want it to be noted as I begin my Senate career here, this is the first committee I've been to because I've been told this is the best committee. So I appreciate you guys having me here today.
Thank you.
For the record, I'm Senator Paul Corderman, representing District 2 of Washington County. Today, I'm here to present Senate Bill 47, Nursing Homes and Assisted Living Programs, Essential Caregivers. As COVID has affected all of us in many ways, unfortunately, this has been a very challenging and tough time for some of our most vulnerable citizens. During the beginning of the COVID-19 pandemic, long-term care facilities and nursing homes were among the first facilities to shut down, and rightfully so. This was and continues to be to limit the public's access in an effort to keep these residents and patients safe. As we know, these facilities are home to some of our most vulnerable population and the home to many of our own family members. When public access was limited, in-person visitation was halted. Again, as we're all aware, this was done in an effort to keep residents safe. However, as you can imagine, because our family members have not been able to see their loved ones face to face, this has had a profoundly negative impact on the residents and their family members. I, like I'm sure many of you, have heard story after story of a patient's health declining significantly due to the lack of human interaction that they have not been able to have from their loved ones. I'm sure there are people in this committee that have not been able to hug their mothers, their fathers, their siblings, or even their other loved ones due to visitation being halted. The intent of this bill is to allow one person or more designated and appointed by the patient to be an essential caregiver. This in turn would allow and afford that person the ability to visit with their loved one, not through a window, but within the facility itself. The designated essential caregiver would still be required to adhere to all safety protocols and/or testing directed by the facility and their staff, and also in accordance with local and state health guidelines. It's important that we allow this process to be determined and defined by these facilities themselves, as they are all different, unique to themselves, and they should have the ability to craft a process that is specific to them and their patients. We know this virus is deadly. However, we must find a way to balance the physical safety with the mental health of our elderly population. And that compassion and love between one another is something that cannot be understated. It cannot be replaced, and we cannot afford it to be lost, even during these most difficult times. In consultation with some organizations that have been reviewing this bill, some of which you will hear from today, we understand the challenges that a bill like this presents. To be clear, this is not an attempt to supersede or reduce powers given during a health emergency, but rather an attempt to find a way to provide the care that our most vulnerable loved ones so desperately need, and quite frankly, have a right to. We should all have the ability to see and visit the people that we care and love for the most, even in these most challenging of times. We look forward to working with members of this committee to work towards whatever language needs to be addressed in this bill or within the public safety article to find and afford the opportunity for our loved ones to have this in place. At the suggestion of some of the industry leaders, we have crafted an amendment to ensure that this would only apply during a global health pandemic or health emergency. However, again, we would like to work with this body to produce legislation to afford our most vulnerable loved ones, again, this opportunity. So thank you for your consideration today, as we respectfully request a favorable report from this committee. And Madam Chair, I will defer back to you. Thank you.
Thank you. You certainly highlight a problem that is running rampant right now during the pandemic. Let me ask you this.
Sure.
We already have, as a nation and in the state of Maryland, a number of official forms that individuals as they age, or even if they're not that old, can fill out to indicate who they would want to fill certain legal and other functions for them. I know you can sign up as to have somebody designated as your health agent if you can't speak for yourself. I'm wondering if what you're describing might be comparable to people that already by other titles are able legally in the state of Maryland and around the nation to do some of the things that you're talking about. Have you thought about that?
You bring up a good point, and again, we're welcome to all suggestions of really, obviously the intent here is to find a way and a path to allow that interaction. So I appreciate that feedback.
Well, one thing you might just want to make this apply if the person has not otherwise signed an official form that's legally recognized in Maryland for a health agent or the person who could help them make decisions or be in a special relationship to them in terms of helping to guide the care that they are getting during a period like this. So we can talk offline later, but I just thought I would bring that up. Senator Benson has her hand up. You need to unmute yourself. Did you unmute?
Thank you very much. Thank you very much. Thank you, Senator, for bringing this bill to. As many of you all know, that I've just suffered within the past 4 or 5 weeks some very trying times and sadness. One of the problems that we found as a family was my sister was in a rehab facility, but she also spent some time in the nursing home. It was very difficult for us to hold the staff and the people at these rehabs accountable. We were sending in flowers and those kinds of items, and no one could tell us whether or not my sister had received the items. We had no way of communicating with her. And I have to tell you all that that did not help with my sister's wellness. The need for having someone to go into, at least one person, one assigned person from the family to go in to hold people accountable for the health and welfare of our loved ones is extremely important. And I want us to miss that. We'll have these other people from different agencies to come forward to talk about the price and this and that. What you just said, Madam Chair, is really the foot in the door, because that one person that's designated to take care of the needs of the individual who may be there would be the person that I would think would want to go in to see what's going on with their loved one. But the fact of the matter is that they were shut off. Our loved ones are shut off from the outside. That leads to depression and all kinds of problems. And so I'm very, very. I want to ask the senator, did you miss what the chairperson suggested in the way of using the assigned individual who is in charge of the loved one's well-being to be the person, the designated person to go in to see to hold the facility accountable? That's what we're looking at.
Yes, ma'am. I did hear that. Yes, ma'am.
Okay.
Okay, all right. Well, you certainly have hit on a very important problem and we got to do something about it.
That's exactly right.
Now, the person who gets the 5 minutes, according to the sponsor, is Grace Knuckles, or Nucles. Okay.
Can you hear and see me okay?
Yes, we hear you.
Oh, great. I'm new to Zoom, so please bear with.
I understand.
Good afternoon to everyone. Thank you for the opportunity to speak in support of the Essential Family Caregiver Bill. I'm extremely passionate about this bill, as I know firsthand through personal experience how critical this bill is for residents in nursing homes and assisted living facilities, and also for their families. In addition, I am in touch with family members throughout the state of Maryland via a Facebook group that is dedicated to promoting the Essential Family Caregiver Program in Maryland. The isolation of nursing home and assisted living residents from their families statewide has had a devastating effect on them and is causing failure to thrive, and in many cases, tragically, is causing their death. This isolation needs to end as soon as possible. Time is of the essence. As to my personal experience, my husband and I reside in Hagerstown, Maryland. My dear 95-year-old mom has resided at a very fine nursing home here in Hagerstown since late January of last year. My husband and I have been a steady presence and support in her life for many years, having served as caregivers at her own personal home for 8 years prior to her going to reside at her current facility. Due to state and local guidelines, my mom's facility has not been able to allow direct contact with residents, contact such as the comforting touch of a hand or the soothing warmth of a hug. Since the first week of last March, when visitation was locked down due to COVID, anyone's only been allowed contact in the case of an end-of-life compassionate care situation. My husband and I have been barred from assisting in my mom's care, providing critical support, or being able to effectively advocate for her for the past 11 months. Let me stress 11 months. That's a very long time to be cut off from your loved one. This has gone on for way too long. We have visited my mom the majority of the time during this 11 months through either a window or glass doors, with intermittent outdoor or indoor visits that did not allow direct contact either. My mother has dementia, and she cannot understand why we do not come inside to visit or have any direct contact with her. Touch is particularly critical to those with dementia. Although I think we would all agree during this pandemic, it has become certainly very important to all of us. We have watched Mom severely decline due to the isolation from my husband and me. She suffers from depression and anxiety as a result, something that she had never suffered from previously. This story is the same for hundreds of nursing home and assisted living residents and their families across Maryland. I cannot begin to adequately express how heartbreaking and agonizing it is to watch a cherished loved one fade away, simply dying from a broken heart. To have my mom reach for us and cry and beg us to come in and hug her is almost too much to bear. I can think of few things more painful than to see a loved one suffering and distraught and not being able to hug, soothe, and comfort them. We, of course, want our loved ones to be safe from COVID, but we also want them to be happy and possess quality of life. They need to be allowed contact with their family in order to thrive and enjoy their final years. Allowing one family member inside to help care for, support, and advocate for them is critical to the overall health and well-being of these residents. These will not be casual visits. They are visits that are absolutely essential to ensure that our loved ones thrive and live their best life possible. And let me note, as I know Senator Quarterman had, that essential family caregivers will follow the same safety protocols as the facility staff members. The risk of spreading any disease will be less, however, for these essential family caregivers, as they will not visit anyone other than their loved one. They will have no contact with others in the facility, nor will they go anywhere in the facility other than their loved one's room. Also, allowing family members inside to help care for, support, and advocate for their loved ones will assist and support staff members who will benefit from the additional help. We must not allow these precious people to continue to decline and die from this isolation. This essential family caregiver program is truly a matter of life or death. Again, time is of the essence. I beseech all of you to please vote in favor of this bill and put this program into effect as soon as possible. My mother's life and the lives of countless other nursing home and assisted living residents depend on it. Thank you very much, and thank you, Senator Quarterman and your staff, for your time and support. Thank you.
Thank you. Are there any questions? All right, we're going next to Julia McLaughlin.
Hello, good afternoon. I, on the other hand of Grace, she's on the outside, I'm on the inside. I work at Farney Keady Home in Boonesboro, Maryland. I'm a registered nurse, former director of nursing, and currently I'm in the administrator in training program. It's been almost a year. So March 13th, we locked down. It was necessary then. 11 months later, the lockdown didn't keep COVID out of our building. We had a very severe outbreak in December that still haunts me. I think about it every day. We had 84 residents affected, 11 deaths. However, I can't tell you how many people died from the COVID isolation that they had to undergo. Just on March 13th, in my written testimony, I talk about a couple. She was here, she had dementia, she was bedridden. Her husband came in every day, 6 a.m. He left every evening around 7 p.m. He fed her every meal. He sat with her. He comforted her. She didn't understand why she was there or where she was, but she knew he was there. And on March 13th, we had to tell this man he couldn't come in anymore for good understanding. She was dead in 2 weeks. No one can tell me she did not die from a broken heart. We couldn't explain to her why he couldn't come in. She didn't understand. She stopped eating. She stopped interacting. We did things like FaceTime. Eventually we would do things like window visits, but that's not the same. It's been 11 months. We have rapid tests. We have PCR swabs. We have vaccinations, screening. We have the proper personal protective equipment. It's time to let these families back in. I can't tell you how many people had to watch their loved one die by looking at them through an iPad. So the last time they saw their loved one in the flesh was last March. And the best we can do is to let them watch their mother, their father, their husband, their wife, in this case, it was 64 years, die through a screen. And that's not okay anymore. It's too long. COVID is here. It's not going anywhere. And we need to learn how to adapt and figure out a way to get some of these family members in, because they're still deteriorating. They might not be as quick as that first lady who died in March, but you can see it. You bring them to the window to visit their family, and the family can see how much they've declined, how much weight they've lost, how depressed they are. They visit outside of my office. I walk out the other day. There was a lady visiting her partner through the window. She said, "I wish I could touch you." And she started crying. So immediately, I'm going to make that happen. But now I have to make it happen through a compassionate care visit, which involves me justifying a reason for a family member to come in and visit their partner. She has to sign a waiver, basically releasing us of liability. I have to rapid test her. Why can't we just do that all the time? Why does it have to be compassionate care? Because someone's suffering from weight loss, depression, or they're dying. Most of these people, when they come in and they sign these compassionate care waivers and visit, their loved one is dying. And that's the last time they see them. And it's been 11 months. And that's not fair. It's not fair at all. And I urge you, I am so passionate about this. I could go on for hours, which I know I can't. I've seen so much. These residents and my colleagues, we are suffering. They have to move several times. When you have COVID, you have to move to another unit. And then when you get out of isolation, you have to move again. And you're still not back in your original room, which is their home. We've taken everything from them. I urge you to please consider passing this bill. And this is someone speaking from the inside. We're ready to have families back and get our residents better. It's the only thing that's going to work.
Thank you very much. Are there any questions? Okay, we're going next to Stephen Rocher.
Thank you, Madam Chairman. Thank you, members of the committee. I'm going to deviate a little bit from my written testimony and tell you that to me, the most important thing in this bill is the inclusion of assisted living facilities with nursing homes. We've got lots of regulations. CMS has put out a letter with a compassionate care criteria. It's mandatory for nursing homes. It is a should be adopted by, quote unquote, for assisted living facilities. So I'm really interested in this, providing the same essential caregiver capability, which this bill provides, for people who are residents of assisted living facilities, as well as those who are in nursing homes. Now, let me share a personal little anecdotal, hopefully not a tearjerker story. But my wife of 58 years is a resident of one of the better assisted living facilities we have in Maryland. She is suffering from what's called FTD, frontotemporal dementia. Not Alzheimer's, it's the second leading cause of dementia. And she's been doing so for about 7 years. Her cognitive decline forced me to put her in an assisted living facility because she and I were the only ones living in our house that we built here in Rockville 65 years ago, okay? And had to place her in. Her intake date was March 2nd. On March 13 was the last time I touched her hand. And if I get choked up, I'm sorry about that. The facility went into lockdown. I've not been able to be with her, touch her, hold her hand, or even be in her room since that date. While we had weekly garden visits, restricted because of the number of people who could fit on the porch during the warmer months, the pandemic is still requiring us to be apart, and now that's shut down, partly because of the weather, okay? We celebrated our 58th wedding anniversary and her 78th birthday with me standing out in the cold outside of a window and with a caregiver from the facility helping her open her presents and read her cards. I was left outside looking in and she didn't know who I was. Okay. As a result, she no longer knows who I am. She physically and mentally is declining, primarily from the lack of contact with me. I'm as essential a caregiver as any member of the staff, yet I am precluded from entry under any circumstances. Worse yet, the current interpretation of essential by the local authorities, by our own county government, does not include assisted living facilities. As a result, clergy can't visit. The podiatrist couldn't come in, the beautician, the occupational therapist and physical therapists, the dentist. As a result, my dear wife developed an infected ingrown toenail that required medical attention because the podiatrist couldn't get in there to do any kind of routine toenail work. She's lost her ability to walk. She's now
I
confined to
hate
a
to
wheelchair.
cut in. Your testimony is so touching, but we're out of time and I need to go to the next person. You want to wrap up?
Okay, let me just wrap up by saying we have got to include in regulation assisted living facilities with the same kinds of safeguards and provide the capability for a family member to be designated to be able to come in. She's missing her teeth and I can't go in her room to look for them, and a dentist can't come in to give her a new set. That's
Okay.
ridiculous.
Thank you very much. Are there any questions? All right, we're going next to Dana Kaufman, who represents Lifespan Network.
Thank you very much, Chair Kelly, members of the committee. Dana Kaufman on behalf of Lifespan, and I want to say up front that we share the frustration of all of the individuals who have testified before me today. During the interim, I spoke to many of you regarding the restrictions on visitation and the mental toll that it was taking on residents. But I think that the issue that we have here and that you need to know is that we were stuck in a box because those restrictions were not the decision of the individual nursing homes or assisted living. They were the result of secretary's orders and guidelines or requirements that were put forth by CMS. And the issue is just, we've been hearing March 13th a lot. March 13th was the date that CMS issued a survey memo to all states, basically saying that nursing facilities had to restrict visitation except for end-of-life situations. That executive or that requirement by CMS was adopted by the state. It was also applied to assisted livings, and it stood until June 26, when the governor did allow limited visitation. But what was very difficult and what many don't understand is the metrics for allowing for visitation under the reopening guidelines was very, very strict. For example, indoor visitation was closed unless you could show 42 days of being infection-free. That's 6 weeks. So if you just look at the community spread, to have 6 weeks, 42 days where you had not one positive case, because an outbreak under CMS is one case, was an impossible standard for many to be able to meet. We did go to the health department to ask for some flexibility. We even sent through one of our members a white paper on ways to safely expand visitation, but that was not done until October 1st, when some of the metrics changed. But unfortunately, then we had the third wave come through, and again, visitation was restricted. The issue with this bill, though, is that was done under the governor's authority. So the solution has to be that the governor opens up. This bill will not supersede that authority. It will also not supersede the directives by CMS. So the solution really has to lie with that executive authority that was issued. I do want to point out that one of the issues also with this bill is that pre-pandemic visitation is a core resident right. And we do have regulations, especially for the nursing homes, that require that visitation be pretty much open-ended. So pre-pandemic, systemically, visitation was not an issue that was raised because visitation was allowed almost unrestricted. So that's another issue because this bill does not separate between pre-pandemic and pandemic. But again, just to conclude, we understand the frustration. We share the frustration, but the solution, and we want to make sure that the expectation isn't something else. The solution has to lie with the governor's authority under his executive powers to open, because that's where we are right now. And we must, as you know, have to comply with the governor's directives. So I would love to have so many questions or additional comments, but I really did want to make sure that you understand the limitations of this bill, given the governor's directives.
I'm going to open up for any other questions, but let me ask about one other. Assisted livings are so varied, from very large entities inside of continuing care communities to other large and middle-sized ones that are independent of continuing care. And then of the very small ones, I have looked at a fairly current list in all of our counties, and it looks like maybe about 3,000. They're in some cases in private homes and in very small locations. Do you think, given what you know, working with assisted living on a statewide basis and on a regional basis, that we would need to consider different criteria and different possibilities given the setting of and the size of a given assisted living? If it's in someone's home and they're just 2 bedrooms that are designated for assisted living as opposed to a place with 30 or 40 or 50 or as a big designated entity inside of a continuing care community. What could you tell us about that?
So there's about licensed assisted living. There's about 1,600 licensed assisted livings. I believe that 72% of them are 9 beds and under. So when you look at that, you could qualify this as being a small business. But I will say that that issue that you raised has been a constant point of discussion. So about 18 years ago, when we were going through one of the initial regulatory reviews, there was a lot of discussion regarding whether or not we should have different regulations for different sizes, because right now we have a one size fits all. So whether or not you care for 2 people, as you're stating, or 200, you have the same regulatory structure. And some of the conversations was around whether or not you should do like 0 to 4 individuals, 5 to 9, and then over up to 16 and then beyond. That was actually the position of Lifespan at the time, 18 years ago, but the state determined, and many of the advocates actually supported, having a one size fits all. I personally think that it should have some additional discussion just because of it is very difficult to regulate under one regulatory scheme when you have such a different operating structure.
Thank you. Are there other questions? Okay. Senator, you've raised an issue that is very personal with a lot of people. I lost a sister to COVID, retired physician in New York and back in May, and we couldn't see her either. We were, they moved her from a hospital to a nursing home for 2 days and then back to another hospital. And in all of those moves, they told us we would be quarantined if we even came to New York trying, and we couldn't get in. So it's tough, it's awful. The pandemic is really impacting in many ways. I don't know, Senator, if you want to consider trying to put a work group together, and maybe if someone like Dana could help you to understand the federal regulations and the state regulations that are applying and the range of differences physically and size-wise, which are also applying. I think we all feel terrible about the stories that we've heard this afternoon, and we already know it's happening. But I'm not sure if in the present posture, the bill can resolve it without our knowing more about what is possible and understanding more about the regulations in Maryland and nationally that impact in this case. So you can get back to us and let us know. We'd like to do something.
Yes, ma'am.
Not be able to get it done right away, but you certainly have brought heart and shed light this afternoon on a situation that's really awful. Thank you.
Yes, thank you, Madam Chair. I look
Okay.
forward to working with you.
All right, so that ends the testimony right now on Senate Bill 47. Thank you. We're going next to Senate Bill 138, Senator Heddleman. She here.
Yes, thank you very much,
Okay.
Madam Chair, Mr.
Okay.
Vice Chair, members of the committee. I'm very happy to be here today in support of this bill. This bill would allow employees of the Baltimore County Public Library System to organize and establish a collective bargaining process. The BCPL plays a vital role in the community. We have 19 branches, over 5 million visitors annually, and provides computer access to nearly 1.1 people. This bill would give the opportunity for labor professionals to represent their interests and open the door to better communication, greater transparency, and a more equitable workforce. There are 2 other libraries in the state, Montgomery and Prince George's, that already have the power of collective bargaining through their union. And in 2013, this body enabled Howard County Library System to do the same. Throughout this pandemic, much of our community has relied on the Baltimore County Public Library System to stay connected, and they have responded with gusto, with a lot of services to ensure that children who don't have access to broadband can still learn, and with creative programming that connects and educates the public. 46% of their employees are part-time and do not receive access to a pension program, which is strictly based on employee contributions alone, nor are they eligible for dental or healthcare coverage. And collective bargaining would give these frontline workers the opportunity to organize and relate their concerns. We have had a number of meetings, well, actually one meeting with the Board of Trustees and our brand new library system director, and I think she may have just started 2 days ago. So we welcome her. I believe that there are some amendments some differences that I think we can work through throughout this process. So I'm very happy to have my constituent, who you'll hear from, Maureen Walsh David, who is the chair of the Board of Trustees of the library, and welcome the wonderful librarians and union labor representatives who are on my panel. So thank you very much for the opportunity, and I'll turn it over to them.
All right, and Ms. Laurie Edwin has the 5 minutes, so you go first.
Thank you so much, Madam Chair Kelly and Vice Chair Feldman, Senator Heddleman for that wonderful introduction, and all the members of the Finance Committee. My name is Laura Ewan. I'm an Associate General Counsel with the International Association of Machinists and Aerospace Workers. And I'm here today with Bridget Fitzgerald, one of our organizers, along with 2 librarians, Rachel Medina and Lauren Buell. I'm honored to be here today to speak to you about SB 138. We think this is a crucial piece of legislation that will grant the Baltimore Public Library System's employees the right to select a representative of their choosing to bargain on their behalf for their wages, hours, and working conditions. Now, I know that a lot of you already understand the importance that unions play in our society, and they've fought throughout our history to give us many of the benefits that we enjoy. I say we in quotes because I know lawyers and senators worked around the clock, but things like a weekend or limits on how many hours you work in a day or child labor laws. These are things that unions have fought for, and working people turn to unions to protect their rights, but to improve those working conditions, their pay and benefits, and to give them really, most critically in this day and age, security on the job. It means having somebody who will stand up for you at the workplace and can voice your concerns without putting you directly at fear of retaliation or reprisals like that. And workers today need a union voice more than ever. I think, Senator Hedelman kind of hit on it. These librarians have responded to the COVID-19 pandemic with gusto. They're providing, even before the pandemic, they were providing services to their community that were crucial, that go well beyond just checking out a library book or a video to someone. And in the time of COVID, they are putting themselves out there in contact with the public and putting themselves at risk. But by choosing to come together and to work collectively, they can have the strength to improve their safety and security at the work site. So that's why we're here. Now, you're probably familiar with the fact that in Maryland, each county library system exists as a creature of state statute. When we first looked into how we could organize these workers, we actually did our research. We talked to a lot of different people and found out that it wasn't just so simple as filing some representation cards with the county clerk. We actually had to go through, this whole process being here today, because the state laws don't automatically grant boards of trustees of the county library systems the right to enter into a binding collective bargaining agreement unless the legislature gives them permission. But fortunately, we have 3 counties now that we can look to who have undertaken steps to allow their library employees to be represented for purposes of collective bargaining. And 2 of these 3 counties have done just this. They've come to the legislature and they've sought permission and been granted that permission. So we talked to the county executive's office. We read all these laws and county codes that applied in these other counties who have already gone down this road. And we looked at the particular circumstances here, the culture, the conditions at the workplace here in Baltimore County. So you're going to hear a lot about Howard County and how Howard County has the legislation that was passed that outlines a lot of different provisions. But I want to make something very clear. The amendments that have been put forward cite exclusively to Howard County. In fact, it's basically been presented as Howard County's law with highlights indicating, oh, this wasn't included in the Baltimore County proposed legislation, so we should put it in there. No part of our law was written, borrowed, mirrored from any other law without careful consideration of the rationale and the intent behind its inclusion or exclusion, however the case may be. We didn't copy Howard County's wholesale and put it in there because it didn't make sense for the circumstances in the Baltimore County Public Library system. So some of these edits, if they're just applied across the board, will actually cause the legislation to not make sense. So for example, it was flagged that in the Howard County legislation, they spelled out the need for 3 distinct bargaining units. They had one, I believe, for technical employees and another one for another class of employees. Now, maybe the organizers of that campaign thought that that would be appropriate to come into bargaining with 3 predetermined bargaining units, and that's fine. But the employees who have come to us come from across the Baltimore County Public Library System group of employees, and they want to come in and bargain collectively as one group. So why would we put in 3 distinct bargaining units when that's not what these employees are asking for? In addition, throughout a representational proceeding where you seek an election to see if these employees actually want to be represented by a union, normally that's where individuals would come forward and spell out what the bargaining unit would look like. So it's not even necessary in establishing legislation like this one. And if you look at some of the other examples, for example, I believe Prince George's County, they don't spell out 3 distinct bargaining units.
I hate to ask you to wrap up, but I'm going to need to, if you could.
Absolutely. No, I'll get to the point. But to us, that's just one of the examples. And we've submitted extensive testimony on some of the other problems. To Senator Hedelman's point, there are some proposed amendments that would not substantively change the nature of the bill. But ultimately, what we need here is SB 138 passed as is. This will give these employees the opportunity to go through the unionization process and give them the ability to stand up for themselves and their coworkers on the job. So we thank you very much, and I'm going to turn it over to our other speakers.
Okay, and before we do, Senator Hedelman, we will need a delegation letter from Baltimore County senators. And you're lucky, guys. I'm a Baltimore County senator. Senator Klossmeyer is chair of the Baltimore County Senators, so I'm sure she'll arrange for a meeting at which the Baltimore county senators can express themselves and give feedback to our committee. All right. Let's go next to Rachel Medina. Is Rachel Medina?
Good afternoon. Hello.
Yes.
Hi. Good afternoon, Madam Chair and the distinguished members of the committee. Thank you so much for allowing my colleagues and me from Baltimore County Public Library the honor of speaking to you today. And a special thank you to Senator Heddleman, our bill sponsor and my senator from my district, for bringing this to the committee's attention. My name's Rachel Medina, and I'm a librarian working full-time at the Parkville Kearney branch in Baltimore County system. And I've worked there for my entire 10-year career, starting part-time in circulation and working my way up to my current position as a librarian 3. Throughout the years, I've seen the strengths and the weaknesses of Baltimore County Public Library system. And I really believe that forming a union will allow BCPL staff to negotiate for policies that will help us work together to sustain our strengths and to mitigate our weaknesses. One issue that particularly concerns me relates to BCPL's hiring and promotional practices. I've often mentored and supervised talented staff who end up walking away from a career at BCPL because they cannot successfully navigate our confusing and opaque promotional system. Our staff often perform duties well beyond their job description in the hopes that this extra effort will lead to promotion. And I've participated in multiple hiring panels and seen firsthand how vulnerable our interview process is to racial, economic bias, groupthink, and favoritism. Our staff is our greatest asset, and I strongly believe that having access to union representation is our staff's best hope to have a voice in shaping how BCPL responds to this and other important issues. Passing this bill, SB 138, as is the first step. So help us to make our voices heard and to have the opportunity to work together with our management and administration in pursuit of a better BCPL for both our staff and our customers. Thank you so much for your time and attention, and I urge a favorable report on SB 138. Thanks.
And thank you. Are there any questions for this witness? Okay, we're going next to Lauren Buell.
Thank you, Madam Chair and Vice Chair and members of the Finance Committee. This is my first time testifying, and it is an honor to have the ability to speak with you on the importance of having a union for the Baltimore County Public Library staff. My name is Lauren Buell, and I have worked with the library system for 3 years now. I'm a part-time librarian and work for the Baltimore County Public Library Essex branch. As a librarian, I'm involved in library-related programs, outreach services, and handle a number of customer service aspects. Communication is very important with any business, and when it is lacking, it can decrease staff morale throughout the entire organization. The union will help us approach management with questions, comments, and concerns on behalf of the entire library staff. Right now, we have no effective way to do that in real time. The way we receive and review staff concerns takes a good amount of time, no matter how time sensitive the issue may be. Especially right now during the pandemic, transparency and open lines of communication are more important now than ever. I believe that having a union and people having their voices be heard. We want respect, and we want our issues that are beyond our control to be listened to, reviewed in a way that makes us feel like our thoughts, comments, and concerns are valid and appreciated. I feel we'll be able to create an environment in which we are all proud of those in the positions of power, will be glad to hear staff concerns and give us a voice. I feel the only way we'll be able to achieve this is if we have qualified labor organizations behind us. They can support us with professional representation and know that the labor laws in the ways that we do not, and help us navigate through the proper channels. BCPL is an amazing organization that I have been and have always been proud to work for. There is always room for growth and improvement, and I believe that our ability to collectively bargain will only strengthen our standing in the organization as a great and wonderful workplace. Thank you for your time and for giving me this opportunity to voice my concerns on legislation that will allow us to be able to collectively bargain. I urge a favorable report on SB 138 as is. Thank you.
Thank you. Are there any questions? All right, if not, we're going to Bridget Fitzgerald.
Thank you, Madam Chair Kelly, Vice Chair Feldman, and members of the Finance Committee. My name is Bridget Fitzgerald, and I'm an organizer with the International Association of Machinists and Aerospace Workers, the IAM. The campaign to organize a union started nearly 2 years ago when I first met with a few employees from the Baltimore County Public Library System, BCPL. Many of you might be wondering how library staff employees came to work with machinists. However, that answer is in who the IAM is a union and what employees want from their union representation. The IAM is more than 130 years old. We may have been born from a secret meeting of railroad workers in Atlanta, Georgia, but we've evolved into an organization that represents workers in just about every imaginable sector in the US and in Canada. We still represent railroad workers, but we also represent employees in the airlines, manufacturing, aerospace, the federal government, as well as county, state, and municipal employees within the public sector. When employees look for a union to represent them, they want an organization that's committed to this process, an organization that will negotiate stellar contracts, protect them and their agreement, and an organization dedicated to educating the membership to work together in unity and solidarity. There are lots of good unions within this labor movement, but I truly believe the IAM is second to none when it comes to what workers want. And BCPL employees, they looked into other unions, but they came to us because they feel that we're the best fit for them. It's not easy for any group of workers to unionize. Even if this legislature passes the bill, it's not a done deal. We still must just justify the interest in holding election, and then we have to win it. With BCPL, there's an additional challenge. It's the state statute created the library system, so we need SB 138 passed just to have the opportunity for the BCPL employees to go through the unionization process. Every employee I've spoken to loves their job. You've heard them talk about it today. They take pride in serving the community and hope to make Baltimore County Public Library System their career. But nothing is perfect. These employees know that having a union will provide an opportunity to negotiate a contract that preserves the best things about their job and improves the conditions not necessarily working well. Essentially, BCPL employees want what I presume every employee wants, and that's the best work environment possible to realize their full potential for themselves and the community they serve. I urge a favorable report on SBL 138 as it is, so BCPL employees can move forward to the next steps in forming a union. I thank you very much for your time and opportunity today.
Thank you. Are there any questions for this witness? Okay. We're going next to a witness who is favorable with an amendment, Sonia Alcantara Antoine.
Hi, good afternoon. Thank you, Madam Chairwoman, Mr. Vice Chair, and members of the committee. My name is Sonia Alcantara Antoine. I am the new director of the Baltimore County Public Library. This is my 4th day on the job, and I'm really happy to be here today. As the new library director, I am committed to making Baltimore County Public Library the best library it can be for our diverse community, and prioritizing effective communication and collaboration with staff so that we can move the library forward together as one team. I was hired by the Library Board of Trustees specifically because I bring that passion and dedication to the role. I'm here today with Maureen Walsh-David, who is our president of the Board of Trustees for Baltimore County Public Library. We support the efforts to allow Baltimore County Public Library employees to pursue collective bargaining. We are proposing amendments to the bill that will ensure clearer employee protections and make it consistent with legislation guiding collective bargaining for libraries across Maryland. Baltimore County Public Library is a public library system that is governed by a library board of trustees. While much of our funding comes from Baltimore County and we have a collaborative working relationship with the county, it is important to note that library employees are not employees of the county. The library board determines library policy, rules, regulations, bylaws for the library and the conduct of its business. We currently have 575 staff members who are a critical part of our organization, and it is their creativity and innovation that drives our ability to serve your constituents in new and exciting ways. And we are so grateful for their work. Again, library administration respects and supports the right of employees to pursue collective bargaining. We support this bill if there are amendments. We believe our amendments to the bill will ensure the management rights that will increase employee protections and clarify essential elements of this bill that are currently unclear and inconsistent with our sister jurisdictions. For example, the definition of employee and bargaining units, an ambiguous reference to Baltimore County collective bargaining law, which does not apply to library employees. We are currently working with bill sponsors, including your colleague, Senator Hedelman, to draft amendments. Our proposed amendments will make this bill effective, clear, and more closely aligned with legislation passed by this body in 2013 that address the same concerns in another jurisdiction of the state. The bill is unworkable in its current form. We want to be sure that we have a bill in place that is clear and fair for all parties. I respectfully request that the committee consider the proposed amendments and ensure that they are included in the bill before giving it a favorable vote. Thank you for your time and consideration. And myself and Maureen are both happy to answer any questions that you might have.
Okay. Well, I'm surprised to find out myself that you aren't actually county employees. So who pays the salaries and the pensions for Baltimore County librarians?
That's an excellent question. Ultimately, the library does that. However, the majority of our funding does come from the county.
Okay. All right. Before I call on the last witness, it's seeming to me that you might want Senator Hedelman to put a work group together. And we might want the chair of our delegation, if she has time, to sit on the work group to make sure when the delegation gets to the point of trying to prepare a delegation response, that it's done timely and that we have considered everything.
Yes, Madam Chair, I'm working with my House counterpart to bring all the parties together, hopefully within the next week, prior to a delegation consideration of the bill. So hope to be able to work out some of these issues.
Okay.
And would certainly love the input and participation with the chair of the delegation.
Okay, thank you. All right, and our final witness is Maureen David of the Baltimore County Library Board of Trustees.
Good afternoon, Madam Chair, Mr. Vice Chair, members of the Finance Committee, and Senator Hedelman. And Senator Hedelman, thank you so much for all your kind words about the library. We appreciate your enthusiasm for all that we do for the county. The Library Board of Trustees is committed to the mission and vision of the library to provide opportunities to explore, learn, create, and connect for a more inclusive and engaged Baltimore County community. We understand and appreciate that our staff is an essential and valued part of the library system, and we support the right of the Baltimore County Public Library employees to seek collective bargaining units. However, as our new director has stated, we can only support this bill if there are amendments to address the issues that she pointed out. We want the amendments to make the bill fair, workable, and consistent with the laws that have already been considered and passed by this General Assembly. Just to quickly highlight some areas of concern in the bill, the definition of covered employees is unclear. There is no section on employer rights and authority in the bill. BCPL employees are not county employees. If they were to be covered by Baltimore County Collective Bargaining Code provisions, it would require a change in Baltimore County Code that would have to be made by the County Council. SB 138 lacks clarity related to a number of important procedural questions, such as certification, decertification, and strikes. Rather, the legislation refers generally to Baltimore County Collective Bargaining Law and not clear provisions, which, as I've already said, doesn't really apply to these employees. There's a couple of technical things. The impasse procedures would require the library to accept and submit to the Board of Mediators recommendation rather than have each side's position submitted for board action and approval. And there are a few missing protections for employees from action by an employee organization under certain circumstances, and no provisions to decertify the union if the employees had decided to do that. I know time is limited, so I've included in the testimony an annotated copy of the statute, 2013 statute of Howard County. We certainly understand that this isn't the only way to approve collective bargaining, but we do appreciate that that bill was very thoughtfully considered by this body when it was passed, and we wanted to highlight to show the extent to which that the SB 138 is inconsistent with that law. We suggest that we could love to work with Senator Hedelman and the rest of the group to amend the bill so that we can create a bill that is workable, fair for all of us, and consistent with prior law. Thank you for your time, and I'm happy to answer any questions that you might have for us.
Okay, thank you. Are there any questions? Yes, Senator Klossmeyer.
Yes, thank you, Madam Chair. Welcome to Baltimore County. How do you, Antone?
It's Alcantara Antoine. Thank you.
Antoine. Well, welcome to Baltimore County. I look forward to working with you. But my question, I guess, is this, you're 4 days in and all of a sudden you have this bill? I mean, are you comfortable with that?
I do support the right of staff to collectively bargain. I'm concerned with the bill in its current form, and that's why I do recommend and I would support the bill if there were some amendments to it.
Okay. And as a delegation chair, I believe Senator Hedelman, you didn't put it in for this week, correct?
Not for this week. We're not ready. We're
Okay.
hoping for next week.
Okay, so we will let you know when that is. So if you would like to testify, Maureen would like to testify, and Lauren would like to testify. So we'll get that all straight out for next week. But again, welcome to Baltimore County.
Thank you.
Okay. All right. Well, that ends the testimony on Senate Bill 138. And thank all of you for enlightening us. Okay.
Thank you very much, Madam Chair.
Okay. All right. The next bill up is Senator Hester, Senate Bill 275, Maryland Department of Health Residential Service Agencies Training Requirements. And Senator, you're up now.
Thank you so much, Chair Kelly, Vice Chair Feldman, and members of the Senate Finance Committee. For the record, Senator Katie Frey Hester. Thank you for your consideration of Senate Bill 275. Last year in this committee, we did have an excellent hearing on this bill. However, it ran out of time for a vote since we ended early. I'd like to thank the Speaker Pro Tem, Sample Hughes, for her strong advocacy and collaborative approach working on this bill to bring all the stakeholders together. Today, as you know, 1 in 3 seniors suffer from Alzheimer's disease or dementia. These illnesses impact so many of our constituents, and I know many of you on this committee probably have personal connections with people with dementia. For the over 1,200 residential service agencies in Maryland providing the staff to those vulnerable seniors, they currently have no mandated training in dementia care and are only visited by the state in the case of a complaint. This is a critical gap that needs to be filled in terms of oversight of quality care. And this bill is a result of a negotiated agreement between the residential service agencies and the groups representing the interests of our seniors and individuals with Alzheimer's and dementia. It is an excellent, mutually agreed upon solution. The legislation in front of you, including its small conforming amendment, raises the bar for the standard of care by requiring that residential service agencies provide their direct care and administrative staff with 3 hours of initial training related to dementia care and 2 hours of continuing education every year. This investment in the workforce will equip the residential service agencies with best practices and a better understanding of how to provide the complicated care required for individuals with dementia. The Alzheimer's Association of Maryland and the Maryland National Capital Home Care Association, representing residential service agencies, have crafted a compromise bill that helps caregivers and their families. I'd like to thank this committee for the work that you have already done to improve the standard of care for over 110,000 Marylanders with Alzheimer's and the countless others with dementia. And I respectfully request a favorable report on Senate Bill 275. And I believe I have a panel here to help provide some of the details and answer any questions you might have.
Okay, thank you. Are there any questions of the sponsor? Okay, we're going then to the person who gets the 5 minutes is Eric Colmaro, I guess it is. Colmaro.
You got that right, Chair Kelly. And thank you, Chair Kelly and Vice Chair Feldman, Eric Colmaro, Director of Government Affairs with the Alzheimer's Association. Thank you for the opportunity to provide testimony today about this important legislation, which requires residential service agencies to provide dementia training for their workers. And I want to talk today, you have my legislation, and just stress that dementia training is essential for providing quality care to Marylanders with Alzheimer's disease or other forms of dementia. Individuals with Alzheimer's have specific needs, including the 95% of them who have at least one other chronic condition, which really complicates their care. Over time, people with Alzheimer's will often lose their ability to use words, which presents added challenges for care workers and stresses further the need for training. This legislation requires that this workforce have dementia-specific knowledge and dementia-specific training on hiring as part of their hiring process, and in turn invests in the future of this workforce. It sets a vital baseline to train direct care staff who work with individuals with Alzheimer's or other forms of dementia and their supervisors. It allows time for training to be developed, and beginning in July of 2022, requires at least 3 hours of initial training and 2 hours of continuing education training for staff and supervisors. It recognizes the logistical and financial concerns of providers and allows the training to be provided online or by an appropriate supervisory staff member. It also notes that if a trained individual changes home care employer, they have the option to not complete the training at a new organization, as long as they have done it and they have sustained dementia-related direct care or supervisory work. I want to thank Senator Hester, our bill sponsor. I want to thank the co-sponsor and the loyal Baltimore City Walk to End Alzheimer's participant, Senator Hayes. And I want to thank so many of you on this committee who have shared your personal connection with me about the cruel disease of dementia. Thank you as well to the Maryland National Capital Home Care Association for their support of this bill. I appreciate MINCA and its Executive Director, Dawn Seek, who serves on the statewide Virginia Jones Alzheimer's Disease and Related Disorders Council. MINCA and Dawn's membership are a workforce that is essential to Maryland before, during, and after the COVID-19 pandemic. A word about the fiscal note. The Health Department has suggested that this legislation, which has fewer training hours, more focused topics, and flexibility for supervisors to provide training, merits the same Medicaid rate adjustment. And I'd just add that if the actuaries who set these rates for the small percentage of home care providers who accept Medicaid think that this would be the same cost as the 2020 bill, a vastly different bill, it's fuzzy math. Let's just say that. I urge a favorable report on this bill because it is the right thing to do, because it will create a more dementia-capable workforce, and because it will aid some of our most vulnerable Marylanders. Thank you for your time.
Thank you. Are there any questions of this witness? Okay, we are going next to all right, to Dana.
Thank you very much, Chair Kelly, members of the committee. For the record, my name is Dana Kaufman. I'm with the law firm of Schwartz, Metz & Wise, and I am here on behalf of the Maryland National Capital Home Care Association. We strongly support this legislation with the clarifying amendments. The issue for us was never the need for the training. It was more of how the training would be required. We really appreciate Senator Hester and Delegate Sample Hughes and the consumer groups such as Alzheimer's for working with us so that we could develop a feasible training that did meet the requirements and the concerns that have been raised. And with that, we urge a favorable vote. Thank you.
Thank you. Also, David Rod, were there any questions for Dan? Okay, then we're going to David Rodwin, Public Justice Center.
Thank you. Good afternoon, Madam Chair, Mr. Vice Chair, and members of the committee. My name is David Rodwin. I'm an attorney at the Public Justice Center, which is a nonprofit public interest legal organization in Maryland. I practice in the Public Justice Center's Workplace Justice Project, where I focus on workforce issues generally, but specifically focused on the state's home care workers and issues that they face. I'm also the vice chair of the board of the Maryland Regional Direct Services Collaborative, which is dedicated to bringing people and organizations together to work to build and sustain a well-trained direct care workforce that meets our state's growing need for it. The Public Justice Center supports SB 275. Dementia training is vital for all the reasons that have already been said. Caring for people with dementia involves particular skills that, as of now, workers are not necessarily being trained in. And lack of training is one of the reasons why our state is facing an increasingly serious shortage of home care workers to meet the needs of our state's aging population. There's a growing body of research that shows that when home care workers get appropriate training, they're more likely to stay in their jobs. This is important because turnover of home care workers is extremely high. The annual turnover rate for this workforce is about 60%, which is one of the highest of any job categories. And this bill alone won't solve that problem, but it will provide an investment in the workforce that can reduce turnover while improving the quality of care that people with dementia receive. I'm very grateful that the Maryland National Capital Home Care Association supports the bill today and recognizes the value of this added investment in their essential workforce. And just as a general note, I think it says a lot that there are so many different stakeholder organizations here supporting the bill, including those representing businesses, consumers, and workers. So for these reasons, the Public Justice Center asks for a favorable report on SB 275. Thank you.
Thank you. Any questions for this witness? Okay, and we're going finally to Tammy Bresnahan, representing Maryland AARP.
Hi, good afternoon, Chairman Kelly and members of the Senate Finance Committee. We too thank Senator Hester for bringing this very important bill to the committee and to the Maryland General Assembly. We support Senate Bill 275. Just a quick little bit of statistics. The number of people age 65 and older with Alzheimer's disease and related dementia is expected to grow from 5.3 million to 7.1 million by 2025. We're going to really need an educated and informed and make sure trained staff to do that. You might be aware that certified nurses assistants who generally work in nursing facilities and home health aides, who the state has them and what they call their IHOS program, and most of their dollars come from Medicare, are required by federal law to have at least 75 hours of training and pass a competency exam. And so we think that this bill is a good compromise and that people need training and ongoing training to make sure that they deal with Maryland's most vulnerable. That we ask for a favorable report.
Thank you. Any questions for Tammy? Okay, thank you very much. That ends the testimony on that very good bill, sounds like. Okay, we're going next to Senator Lee, and she's joined by Senator Washington for Senate Bill 158.
Can you hear me okay, Madam Chair?
Yes.
Okay, thank you, Madam Chair and Vice Chair. Senate Bill 158 was heard last year in EHE. It's jointly assigned this year to Finance, and the House bill passed last year. The bill is really just common sense update to our existing law to encourage working people to vote when they otherwise would be prohibited due to lost wages or retaliation from their employers. This legislation is merely an update to Maryland's election law, Article 10-315, to account for the existing early voting and same-day registration laws. SB 158 allows more Marylanders the opportunity to engage in the sacred democratic process of voting while still being paid for a limited window to vote and not fearing repercussions from their place of employment for exercising this essential right and the specific protection under Maryland law. Early voting is increasingly popular, even with mail-in ballots and drop boxes, which may have hit their peak, especially during the pandemic. According to the State Board of Elections, over 860,000 Marylanders voted in person during the 2020 early voting period. Adding flexibility for all voting days allows more residents to vote, and most importantly, allows the working poor and disenfranchised to engage in our democratic process of voting. This flexibility is only realized in practice for many working poor if we don't expand existing protection to early voting and those who register on election day to vote. Maryland's election law 10-315 already requires employers pay for and allow for up to 2 hours absence on election day if the employee is a registered voter. SB 158 removes the requirement for an employee to be already registered. This changes results in the employee's ability to take their 2-hour absence, register to vote at the polls, and to vote either on election day or during the period of early voting. The additions of the same day voting and early voting require us to update the 2-hour window requirement to allow employers and their employees further flexibility. Last year's perhaps ill-fated SB 666 heard no opposition. Cross-filed with HB 398 this year, this measure has the support of the Maryland Association of Election Officials, the ACLU, Common Cause, Every District, and the League of Women Voters of Maryland. We cannot assume everyone can take time out of their workday to vote on one particular day. Flexibility for early voting should be extending to those who cannot afford to take time off work to vote and who may not have free weekends to cast a ballot either. We have expanded access to the ballot, but for the working poor, this tweak in our law is required to fulfill the promise we have made to other people who have no problem taking time off to vote early or on election day. In the end, anything we can do to encourage voting is a victory for all Maryland residents, no matter the electoral outcome. For these reasons, we respectfully ask a favorable vote from my wonderful colleagues on finance on SB 158 with a technical amendment. We have just learned that the amendment has moved with the bill in the House Elections Law Subcommittee today. And I've given a copy of that to the committee members via my Chief of Staff, Michael Laurie, has sent you that. So I respectfully ask my colleagues to please vote favorably on this. Thank you. And I'd like to.
Before I go to the other, well, are there any questions of the sponsor?
Oh, yes. Any questions?
Okay.
Okay,
Senator
great.
Washington, since you're here representing EHED, is there anything you need to say?
No, thank you. I'm good. Thank you very much.
Okay.
Very straightforward.
All right.
Thank you.
Okay. We're next going then to Janet Millison for the 5-minute testimony.
Thank you. Good afternoon, Madam Chair, Vice Chair Feldman, Senator Lee, Senator Washington, and members of the Finance Committee. My name is Janet Millinson, and I lead the election advocacy team for the League of Women Voters of Maryland. Let me also note that I've worked elections in Montgomery County since 2004, including serving as a chief judge and an early voting center manager. Now, right now, I face that presenter's nightmare of the speaker before me, having made all my anticipated points. So I hope you will view what I'm going to say as reinforcement rather than redundancy. The League of Women Voters supports having an election system that increases voter participation, is fair and accessible, and protects all citizens' right to vote. In recent years, Maryland has moved forward on all these fronts, and this bill recognizes that by updating some existing code that's several decades old. The League supports these proposed changes, and here's why. The current statute requires employers to provide up to 2 hours paid time off on Election Day for employees who are registered Maryland voters and would otherwise lack sufficient time for voting on a workday. The employee must provide proof of voting using a form authorized by the State Board of Elections. Well, 3 elements of this need updating, as Senator Lee just presented. First, people don't vote only on Election Day anymore. Maryland has offered early voting since 2010, and it's become increasingly popular. And I want to apologize, there's a typo in our written testimony. It said 2012 instead of 2010. In the last 2 presidential elections, I went back and looked at the statistics going all the way back. In the last, nearly 1/4 of eligible voters cast their ballots during early voting. So it wasn't just the pandemic election, the one before that also, the presidential one in 2016. In fact, according to the State Board of Elections, this past November, more than twice as many people, approaching 1 million, voted during the early voting period as voted on Election Day itself. Therefore, it makes sense to change the mention of Election Day to voting in an election. Second, it's no longer true that an employee needs to already be a registered voter to go to the polls. In 2016, Maryland started offering same-day registration during early voting, and in 2020, same-day registration for new registrations was made available on Election Day as well. This past November, same-day registration processed over 26,500 new registrants. So it's appropriate to remove the requirement that an employee must claim to already be a registered voter to get time off. So third, although all Maryland polling places do make available an official form to use as proof of voting, many people who work in Maryland are residents of the District of Columbia or neighboring states, and they vote in those jurisdictions. Clearly, these employees can't obtain an official Maryland form. So the bill would make this requirement more flexible by specifying that the employee shall furnish reasonable proof in a timely manner that they voted or attempted to vote. In summary, the provisions of this bill are sensible and overdue. The League of Women Voters in Maryland, which represents more than 1,500 members across the state, urges a favorable report on State Bill 158, Senate Bill, excuse me. Blew the punchline. All right. Any questions?
Yeah, I will. Hey, who was it? Senator Hershey.
Thank you, Madam Chair. Just a few quick questions. Obviously, I understand the portion about the registered voter. That makes sense with legislation that we've passed previously. But right now, how many days of early voting do we have?
It's been, well, traditionally it was 8. It was extended with the emergency regulations, and there's legislation to make it even longer.
Okay, so at least 8+ days.
Right.
So the way that this is written, if an employee has any of those days off that have early voting, then they would not be eligible for the 2 hours of time off during their work day, right? Is that correct?
Senator Hershey, the amendment corrects that and clarifies that too. If you look at the amendment.
I don't have the amendment. So can you explain that, please?
Yeah, okay. Basically, let me give you a scenario, okay?
Well, I mean, I just want to see who this really applies to. So if we have 8 to 10 days of early voting, what this seems to be saying that if you don't have time off during the time that the polls are open, then you can ask your employer for 2 hours to go vote. But if you have time off, then you wouldn't be able to utilize.
No, what it does is, like, for instance, like, you know, like if a employee cannot go on a weekend, which is not a work day, to vote early on a early voting day, which happens to fall on the weekend, he can, that employee can have the 2-hour off paid on election day. And they can also use that to volunteer on election day too.
I don't see where that is if an employee doesn't just decide to go on their own time during a weekend.
Do you have a copy of the amendment yet? Do you have a copy?
Yeah.
Okay.
Well, let me ask this, Senator Hershey. If you've got a point one way or the other, whichever way it turns out the amended bill is, do you want to make that point now? And we'll all take a look at it.
Okay. Thank you, Madam Chair.
So
You
what,
understand, you understand my question? Yeah.
Yes, I do.
Yes. Okay.
Yeah,
thank you.
if you have any questions, just call me. Okay.
Okay.
We'll explain it to you, Chairman.
Thank you very much.
I think the chairman understands what it is too. So anyway, thank you. Thank you for
and
that.
I do want to say to the last witness that I'm glad that I'm a leaguer, both in Baltimore County and League of Women Voters of Maryland. Okay, I'm glad you're here. Okay, let's go now to Stuart Harvey from the Maryland Association of Election Officials.
Good afternoon, Madam Chair, members of the committee. My name is Stuart Harvey. I'm the election director in Frederick County, and I'm co-chair of the Maryland Association of Election Officials Legislative Committee. We represent the local boards of elections throughout the state of Maryland, and we're here today to offer our support on Senate Bill 158. We have also seen the clarifying amendment, and we support that as well. We just want to echo what Senator Lee has said and what the League has said. We think this is a common sense update to existing election law because it does cover people who want to take advantage of same-day registration and also take advantage of early voting. So this is really just an update to existing election law. So we would ask the committee to give the bill a favorable report. Thank you.
Thank you. Are there any questions? All right, thanks so very much. And that ends the testimony on this good bill. Okay. We're going next to Senate Bill 194, Senator Benson. And let's see. Correctional services, inmates, labor, job training, and education courses. All right, and Senator Peters is here also on this bill, from representing budget and tax. Got to see that we don't break the bank. Huh? Okay.
Thank you all. Thank you very, very much. Let me just start off by telling you all that what started this all was there was a young man, and he's going to be testifying in favor of this bill, who sent me an email. He's a student at the University of Maryland with Dr. Freeman Hrabowski. You know, I get excited when I call Dr. Hrabowski's name because of what he does for students at that university. And he sent me a letter that was very, very sobering. And it had to do with the labor and the correctional services and the labor and the job training and educational courses for persons who are incarcerated. And together with Dr. Hill over on the House side, we began to take a deep dive into what this young man was talking about. And then we, of course, had a conference with him through the University of Maryland. So I was so taken aback at what we found out, and I just felt compelled to put this bill in. And so I'm going to ask for your indulgence as we give this testimony, please. It's correctional services, inmates, labor, job training, and educational courses. Good afternoon, Chairwoman Kelly and Mr. Vice Chair and esteemed members of the Finance Committee. Senate Bill 194, correctional services, inmates, labor, job training and educational courses prohibits the compensation rate for inmate labor in Maryland Correctional Enterprise, MCE, from being less than the state minimum wage. The bill prohibits the Department of Public Safety and Correctional Services from deducting the cost of food, lodging, or clothing from an inmate's earnings. The Division of Corrections must offer job training and educational courses to all inmates who wish to participate as specified. This bill in its entirety will help inmates receive appropriate treatment and resources that will help the inmates thrive and stop the exploitation by a system that makes over $52 million from sales, which includes products such as furniture, flags, and license plates. Now listen to this. Wages for inmate labor ranges from 90 cents to $2.75 per day at the Department of Corrections, which is based on their skill levels. In comparison, the state correctional facility inmate laborers are paid 17 cents or $1.16 an hour. Inmates receiving a wage increase will be beneficial toward their release. Additionally, this bill will create a positive, long-lasting effect. Studies have proven that inmates who complete educational courses and programs during sentencing not only have lower odds of returning to prison, but higher odds of finding a job. This will not only help them thrive inside of prisons, but when they return to society, and they're going to do that, inmates having educational courses keeps them occupied while serving their sentences and will increase their self-esteem and ultimately change their behaviors. Inmates receiving a fair wage and education will help to change their lives. Inmates will have better odds of returning to society. They will be able to provide and take care of their families and even allow those seeking education to leave prison and seek even higher educational opportunities. This bill will allow inmates the opportunity to utilize the skills learned in prison and better their lives after completing their sentences. It is therefore my request that you give this bill, Sentence Bill 194, a favorable response.
Thank you. Are there any questions of the sponsor? Mr. Reedy.
Thank you. I've spent a lot of time when I was younger visiting in prisons, doing some different ministry things when I was younger, and I really appreciate the passion to try to help our inmates. You know, in the Judicial Proceedings Committee, we worked a lot on reducing recidivism and figuring out ways to do that. But, you know, I look at the fiscal note of this bill, and it starts at almost $20 million and goes up to 28, 29 million. Have we thought about, have you and your team thought about some ways we could find a way to help this, but not have to be that expensive? So it's just a very large fiscal note.
Well, I would think, first of all, listen to me carefully. You know, I've been around a long time. When there is a desire to not pass a bill, sometimes people use the fiscal note to discourage us from passing a bill. Now, I've been around a long time, so I know what I'm talking about. The second thing is that is the reason why we have my great friend, Senator Doug Peters, sitting with us today, because he's going to help us with that.
I really look forward to hearing that. It might, the large fiscal note might also reflect the, you know, certain certain realities. Of course, we force you're right that we force small businesses, including very small businesses, to pay a wage that is extremely high and very difficult for them. So, I mean, maybe what's good for the goose is good for the gander. Thank you, Madam Chair.
Well, here's the thing. If you look at how much they're paying these inmates an hour at making license plate, what marketable skill do you think that would provide for them once they leave? The job skills that they offer these inmates and the educational opportunities do not prepare them for when they leave the prisons. We've got to do a better job. We're interested in reducing the recidivism rate. And if we educate our inmates, provide them with marketable skills and pay, my God, 17 cents. Think about that for a minute. And that's unacceptable. You all know that's unacceptable. So we've got to do something about it. And I'm hoping that we can work very closely with Senator Doug Peters and with his committee so that we can come up with a bill that's going to offer a favorable report. We've got to do something. And when you hear this testimony from this young man who's a student, who's a graduate student at University of Maryland, I think it would also be very helpful.
Improving skills, I totally agree with you on that one for sure. Thank you.
Yes, thank you very much.
Thank you. All right. Senator Hershey. Oh, Senator Hayes.
Thank you, Madam Chair. And thank you, Senator Benson, for introducing this bill. It's actually been an issue that I've been looking at really closely, and I'm not sure if you had a chance to look at some of the information around Maryland Correctional Enterprises, but in the late 1900s, the federal government actually made it against the law to transport prison-made goods interstate, so from state to state. And so they recognized the fact that we had a history of exploiting prisoners in very low wages. And so what we did as a state of Maryland, we said, well, we'll legalize it here. And so thereby recognizing the mistakes that the federal government did and abandoning it, we actually legalized it here. And we now have a system that is definitely exploiting those workers that are behind bars. And so thank you so much for bringing this legislation. I think, out of this, there's some other things that we should be looking at, but I think this is definitely a step in the right direction.
Thank you so much. Thank you for that.
Okay. The main witness, the one who gets the 5 minutes, is Julian Holman from the University System of Maryland Anti-Prison Labor Coalition.
Hello, thank you for the opportunity to speak. To the Vice Chair, the Chair, and the Honorable Committee, my name is Julian Holman. I'm a citizen of Prince George's County, a University of Maryland, Baltimore County graduate student, and a University System of Maryland Anti-Prison Labor Coalition member. I wish to express my support for SB 194 before you today. Prison laborers make as little as 17 cents an hour for a 4 to 5 day work week, according to one of MCE's own reports. This can be reduced further by deductions for room and other items. Additionally, spending time in prison halves annual earning potential, resulting in massive career losses and hurting the families of the incarcerated. This harm is disproportionately visited upon Black people. 70% of incarcerated Marylanders are Black, despite Black people comprising 30% of Maryland's population. Ultimately, for pennies a day, an overwhelmingly Black prison population produces items such as the state license plates on the car you ride in, the chairs and desks we sit in at a Maryland school or state house, and the masks and sanitizer used by state employees to combat COVID-19. And just for some context, these people do not have access to the masks and sanitizer themselves. There's actually been a huge shortage of personal protective equipment among the incarcerated. As a product of the Maryland educational system, learning this made me feel incredibly ashamed and embarrassed. Many USM community members I've spoken with share this sentiment, which is why the Anti-Prison Labor Coalition was created. This is slavery, and unfortunately, it is entirely legal under the 13th Amendment. Neither slavery nor involuntary servitude, except as a punishment for crime whereof the party shall have been duly convicted, shall exist within the United States, is what it reads. The true solution to the problem is to remove any incentive to imprison our most vulnerable. Until the passage of a divestment bill partnering with unions and trade groups to develop more relevant training and education, providing fairer pay, and holding the Department of Public Safety and Correctional Services accountable to reporting to the legislature will orient Maryland correctional enterprises away from profiteering and towards rehabilitation, empowering incarcerated Marylanders. So in closing, I just want to share a few more things. I provided testimony for the companion bill in the House recently as well, and a few things that other people mentioned. One person who was a former MCE clerk who made the high end of MCE pay stated that MCE makes products and sells them at market rate. Although some people who made a lot less only have to work 1 day a month, and at 90 cents a day, or even more little than that, that won't give you any money for things like Christmas gifts for your children, payment for court-ordered restitution, and other obligations. And additionally, people who fall short to cover these financial obligations are often in need of consulting family members, asking them for money, and oftentimes these are family members who may not have that much money themselves. It's not really voluntary to be in MCE working. You have to be in work, school, or something else, so it's not really a choice, as some people say. As MCE said, the CEO of MCE and the Chief Administrative Officer of MCE were also at the House hearing testifying as well. They were very against this, obviously. They stated that paying the inmates higher wages would reduce their ability to support themselves as a program. So this program is predicated upon paying poverty wages to these people. The existence of this program relies on them.
But you are exceeding your 5 minutes. If you could wrap up.
Okay, I will wrap up now. Thank you for the opportunity to present testimony, and I urge all senators to return a favorable report on SB 194.
Thank you very much. Are there any questions of this witness? Okay, we're going next to Alonzo Turner Bay, Maryland Prisoners' Rights Coalition.
Is I'm unmuted?
I hear you now.
Yeah, my name is Alonzo Turner Bay. I'm in support of Senate Bill 194. I was recently released from prison on October 16, 2020, after serving 31 years, 6 months, and 15 days as a juvenile lifer. I'm requesting that this committee pass this bill because it's very important that we start paying men and women in the prison a decent living wage. For all the work that we do for Maryland Correctional Enterprise, formerly known as State Use Industry. Over the years, I've held several jobs. Example, I worked in a hospital where I did sanitation work. I handled biohazardous waste. I cleaned up blood. I was a nurse's aide. I feeded inmates. I bathed inmates. All of this for seven days a week. And all I made was $1.20 a day. No days off. And while working for Maryland Correctional Enterprise, I worked for another job I held was in the sign plant 111. My job description was sign fabrication, screen printing, typesetting, quality control, and removal of hazardous chemicals. I made all the signs that are in state buildings, that are on emergency vehicles, that are on street signs and all. The most I made was $3 a day. That's as long as I worked overtime. It is important and it is imperative that we start giving prisoners a fair and decent living wage. I worked one of my last jobs was working in a meat plant where I was a meat cutter, a butcher. All the meat that I served in all correctional institutions, all state buildings, Annapolis, and all colleges, they come from an institution. I worked there for 2 years. The most I ever made was $110 in 1 month. Now, it is important that we give a reasonable living wage for prisoners because the funds that are used, we use it to buy soap, hygiene items, laundry detergent, clothing that we need, stamps, writing paper, envelopes, and things of that nature so we can write our family, our lawyers, the courts, to pay for copies are 20 cents a page inside of the institution. Make phone calls, buy tennis shoes, boots, and other items that we may need, such as religious books, reading books, and other material. By making a living wage that's decent for those who are inside, we ease the burden off of our families. My mother is in her 70s. She's a widow living here in Prince George's County. Due all the way up to my last release, I used to have to lean on my mother and ask her to help me pay for things right before I released. My last job was for Maryland Correctional Enterprise, laundry. I made 95 cents a day. At the end of the month, I brought home $28. I washed the clothes from 7:30 to 2:45 in the evening. It is imperative that we give a living wage increase due to the fact, look at all the millions that we give MCE.
Okay,
At least
I hate to butt in, but we're over time. You want to wrap up and they may have questions for you.
I hope, I'm finished. I hope someone do have questions.
Okay, any questions of this witness? Okay, we're gonna move now to Philip Karoom, Judge Karoom. He's a former judge who heads the Maryland Alliance for Justice Reform. Judge Karoom.
Thank you. Madam Chair, Senator Benson, members of the Finance Committee. Initially, let me say I'm on senior status, only working part-time, but I'm not speaking for the court system but today, just for the nonprofit group Maryland Alliance for Justice Reform.
Okay.
We strongly support SB 194 for all of its good approaches. And I can say from 20 years as a judge and before that a prosecutor for many years, that recidivism is the single most important goal that we should have for our prisons. We want to make sure that people come out of the prisons better than they went in, and that they don't come back again costing taxpayers $40,000 per year and committing new offenses. If we can stop them, turn them into law-abiding productive citizens by their time in the prison, so much the better. The minimum wage part of this bill is desirable in that it could help prisoners when they're released and returned to the community have some money to help them get a fresh start. Currently, they're all released basically as paupers with virtually no money at all. And that cannot be good for them finding a place to stay and getting along by lawful means when they're first released. But, and I underline this, even if you didn't approve the minimum wage, if you decided to take that out of this bill, the rest of the bill is very, very good and doing things which I think would not have a $20 million fiscal impact, but would still make things much better for the operation of our prisons. The other things that the bill does is that they require all prisoners be participating actively in education or job training programs. Currently, that's not required, and they don't do it. But education is one of the two top things that would reduce recidivism. According to a RAND Corporation study, it reduces recidivism 43%. Employment, if someone gets good employment skills, that reduces recidivism also by about 50%. So those two things right there, if they were mandated, would be things which would help a lot in reducing recidivism and the cost to taxpayers of our prisons. Last and most important in this bill is the statistics requirement, asking that the Division of Public Safety and Corrections every year make a report of how many are in this kind, that kind of educational job training program, and let you know how close they are to the goal of having 100% education or employment behind the walls. This information is not shared currently. It's not online with their research and statistics webpage. If you go to the library, you can't find it. You would have to do a public information request, and who knows when they get back to you. But that's very important information that you as legislators and we as citizens ought to have. We ought to know how close they are to this goal of actually rehabilitating everyone with education and employment. So strongly encourage you to give a favorable report. If you have to take out the minimum wage or phase it in, if you only doubled the wages that are paid right now to be $1.80 a day, that would be a huge improvement. But the other provisions, again, asking for education and training and annual reports for all prisoners are still excellent parts of this bill, even if you didn't like the minimum wage. So we strongly encourage favorable report for SB 194. Thank you.
Okay. But you do believe, Judge Karoum, that it won't break Maryland's bank, given all the things we spend on, if we were to in fact give a minimum wage for the work we actually make a profit on as a state.
Absolutely. Or if you phased it in. Today, this is a COVID year where it's perhaps a little more difficult to fit things in the budget, but suppose you phased it in over 5 years. It would be still a huge improvement, and I think something that the correctional enterprises could fit its budget around.
Well, you're giving us some ideas for negotiations. Okay.
Madam Chair.
Any other questions for?
Yeah, I want to ask Mr. Turner Bay, what are you doing?
Well, now he's already testified.
I just wanted to ask him that question, if I may.
All right, Madam Sponsor, I'm going to give you this one question. And who are you directing it to, Mr. Alonzo?
I wanted to ask Mr. Alonzo Turner Bay, what are you doing now? Has it been difficult for you to get a job?
Yes, because MC didn't give me no marketable skills that I can use out here. So I'm relying on other people to aid and assist me in trying to help me find work within the state of Maryland or the county.
Thank you.
Okay, thank you. All right, let's go next to Anisha Jumpin from Prison Resistance Project.
Good afternoon. My name is Aisha Jamiluddin, and I'm a Maryland resident and a member of the
Can you
University.
speak up a little bit more?
Okay, I'm sorry. My name is Aisha Jamiluddin. I'm a Maryland resident and a member of the University of Maryland student activist organization, Prison Resistance Project. I'd first like to thank Madam Chair Kelly and all the members of the committee for allowing me the chance to speak today. I'd also like to thank Senator Benson for introducing this legislation, which will ensure that incarcerated workers in Maryland are paid fair wages and will receive important job training for when they're released. So right now we're witnessing a cultural movement wherein elected officials are finally addressing the structural racism within the criminal legal system. However, this has to include addressing the exploitative practice of prison labor. In 2019, incarcerated workers working in the Division of Corrections were paid between 90 cents to $2.75 per day, while Maryland Correctional Enterprises workers made between 17 cents and $1.16 per hour. Those numbers are a moral abomination. The whole point of the minimum wage is to reduce workers' exploitation at the hands of their employers. Yet there are no protections for workers incarcerated in Maryland who are paid barely anything. With the current wages in these facilities, the state is undoubtedly exploiting its workers. Additionally, almost 80% of incarcerated Marylanders are Black, so allowing this exploitation to continue is antithetical to making progress toward racial justice. Anyone who ignores this practice's violently racist nature and roots in slavery is complicit. Not only are these unfair wages immoral, but they also contribute to the financial instability that incarceration already causes. Incarceration takes people away from their jobs and lives, which often leaves families without the financial support they need and contributes to the underdevelopment of their communities. Incarcerated people also have to pay for everything from clothing to basic hygiene products through commissary, where items cost much more than they would outside of prison. They also have to pay in order to call their friends or family. Paying these workers a minimum wage is necessary to mitigate the financial burden they face from incarceration. Furthermore, having a criminal record makes it difficult for those incarcerated to find employment upon release, so providing these individuals with job training is the least the state could do to help them effectively re-enter society. So, to conclude, I'd like to highlight demand number 2 from the 2018 nationwide prison strike, which calls for an immediate end to prison slavery and that incarcerated workers must be paid the prevailing wage in their state. Therefore, we strongly encourage you to give a favorable report to this piece of legislation. Thank you for your time.
Thank you. Before we go to the next witness, I'm wondering if anybody who's already testified or this witness knows of any state that would be a model we ought to take a look at, or something that is reasonably funded, but not so exploited. Just raise your hand. Okay, I'll give you a couple of minutes to tell us which state, Mr. Alonzo Turner Bay. If you can unmute yourself.
The federal prison system has a project just like MCE, but it's called Unicor. And they pay like $400 to $500 a month to all prisoners who work in Unicor. This allows prisoners to save money and send money home to their family. If you're making $500 a month, that's a nice and decent amount to help you out.
Okay. Is there anybody else? Okay. And we didn't give people a chance to ask you any questions. So for the last witness, are there any questions for her? Okay, thank you. Are we going next to Stephen Sanders, Maryland Correctional Enterprises?
Good afternoon, Chairwoman Kelly and members of the committee. Thank you for allowing me some time today to speak. My name is Stephen Sanders, and I am the CEO of MCE, Maryland Correctional Enterprises. We are an active rehabilitation and vocational training program that is offered to the inmates at no cost to Maryland taxpayers. We are a 100% self-supporting state agency that offers hope for a better future to the incarcerated population. Our mission is to provide training opportunities to inmates to instill positive work skills and work ethics to enhance chances of success upon release. We operate similarly to an internship program, but provide a monetary incentive for inmates that voluntarily participate in our program. In addition to the hourly wage, which a lot of us have been referenced to today, MC inmates are eligible for production bonuses, longevity pay, overtime, and 10 diminution days or credits per month, which help to reduce sentence time for eligible inmates. So an inmate that works for us on a steady basis could very well reduce their sentence by 4 months a year. When busy, MCE inmate workers can earn nearly $800 per month unless court mandated. There are no monetary reductions from their salaries for anything that comes from MCE. There's no reductions for clothing. There's no reductions for boots, coats. They are supplied by the institution, not by MCE.
Could I butt in and just ask you what percentage of the incarcerated population are you referencing with these advantages?
Currently, the target employment for MCE is 1,500 inmates across the state. The inmate population at the time is between 18,000, 18,005. It's seen a great reduction because of people being released of late. Right now, because of the pandemic, we don't have the opportunity to hire so many because of social distancing. In October, we had 772 approximately on the rolls, but we locked down many of our locations for months to try to curb the spread. We are back to approximately 550 to 600 inmates that are working every day right now.
Thank you.
All right, may I continue?
Yes, you got about a half minute left.
I'll try my best. In order to sustain our programming, MC does not sell products and services to, or sells products and services only to a restricted market, government agencies and nonprofits. MC operates at a minimal profit as the majority of our revenues are invested back into our program and provide more opportunities for incarcerated population. Our goal is to operate at a 3% profit so that additional resources can be allocated to our training programs. Given our small profit margin, it would be impossible for MC to sustain the additional $30 million in expenses that this bill would bring forth. The implementation of the bill would cause the bankruptcy of MCE. Financial dissolution of MCE would result in an end to our programming. It would require the the state of Maryland to finance the additional 30 million throughout the general fund. Should those funds not be available, MCE should be forced to at least decrease programming from 1,500 to 80, which would not have enough participants to viably continue our program. If MCE should shutter or forced to shutter to reduce operations, we would see numerous inmate opportunities lost and dozens of state employees would be terminated. Currently, MCE is able to offer employment to returning citizens who account for 20% of our workforce at our headquarters office. This financial strain on MCE would eliminate future post-release opportunities. Due to the detrimental impact of this legislation, we respectfully request that the committee vote against the implementation of a minimum wage for MCE participants so we could continue to offer this vital training to our inmate workforce.
Now, let me ask you this question. One of our earlier witnesses with personal experience with your programs has said that they didn't end up with any marketable skills once they were released. And I guess the more I thought about it and I wondered about it, is it because you have the lock in Maryland on the things like the license tags and all, so the things that they were taught to do aren't things that they can get independent work doing with a salary once they are released. Is that the case?
It is not. It's an excellent question. I believe the gentleman was referring to his work in the tag plant where they make license plates, but the tag plant has other opportunities in there and other transferable job skills. We make picnic tables in there. We make silkscreen uniforms. But most of all, we teach quality control matrix, statistical process control, lean manufacturing, workplace organization, team concept.
So if the average inmate upon release who's been in your program were to walk out and say, well, I know something about some metrics that I learned in there, was that going to help them basically to get a job? I just guess I'm wondering how transferable the skills are given the outside economy to which they return.
Right. We focus on transferable skills, and the opportunity for an inmate to transfer to another business unit that may build their skill complement is also available. I worked for General Motors for 30 years. I've interviewed a lot of people and I've listened to what they have to offer. And transferable skills, the ability for many of our inmates to learn how to do the administrative side of the business. They're referred to clerks.
But let me ask you this. For the size of your program, even when we're not in a pandemic, when it's up at optimal levels, and for the rate at which we are discharging inmates from prison, about how many do you think per year normally leave with very transferable skills that, given the Maryland job market, they are able to go to work if people aren't prejudiced against them, which is another problem?
Right, that is a problem. But I'll answer that in two pieces. The fact that they could put on their resume that they worked for MCE, for most employers, gives them a leg up because they understand our program.
But about how many per year
I can tell you that
of your former people are graduating from prison and could even make that claim?
Right, okay. So statistically, even in the pandemic, since March, through our program, those that work for us, 120 have gone through MCE reentry to the Department of Public Safety and Correctional Services reentry program, and 80% of them have found jobs.
And about how many people does that 80% represent during this period?
I don't understand the question.
You said 80% of them. I'm just asking in terms of just actual numbers, how many?
Well, out of 120. So, I'm not a mathematician, but I would say rough figures, 100 would be 80. So maybe 90 of the 120 went out there and are already actively working.
Thank you. Are there any other questions of this witness? Senator Hayes.
Yes, ma'am. Thank you, Madam Chair. Mr. Saunders, your position at MCE wasn't identified on the sign-in sheet. Can you remind us what it is?
Yes, sir. I am the Chief Executive Officer of MCE.
Okay, all right. And, you know, I'm very grateful that Senator Benson brought this bill before us, because just this interim, I had invited some folks from MCEA out because there was a business in my district that was interested in hiring some of the individuals that came through the training. And I got a really terse email from MCE who emphatically refused to come and visit this organization because of whatever reasons, and they cited the pandemic. But in doing so, it forced me to start doing a little bit more research on the operations and stuff there. I know throughout the testimony today, a couple of my colleagues has raised questions about the cost of this program. Are you able to tell us how much MCE generated last year?
Last year, there was a 55 million worth of sales. The profit for last year was approximately 76,000.
76,000. That's interesting because in your annual report, it does cite that you guys raised about 55 million, but it shows the net, and I'm assuming that's the profit. The way it's worded in your annual report, it shows a net of about $30 million.
That is, my Chief Administrative Officer is also testifying today, and he can explain that to you.
No, that would be fantastic. And, you know,
and I must apologize for that, for what the experience that you had. And if you
don't worry about it, I knew we would see each other again, so I wasn't.
Yeah, I'm sure.
Yeah. And so the other thing that I was curious about, the chair had brought up the issue about looking at what skills are being trained on the inside to prepare those individuals to transition back in society. I know MSDE and other organizations are looking to the industry to find out what marketable skills there are. I know inside there's a huge operation around printing, which is kind of like a dying industry. I'm curious at what steps do you all take to see what are the marketable skills that can earn a living wage from behind the walls? Is that evaluated on some consistent basis? What does that look like as far as identifying those skills that you are providing on the inside?
Right. We do look at that twice a year at the least. Printing is a dying age, but companies like Downtown Press have already hired our folks and are looking to hire more because the skills that we provide in a dying industry for an industry that is trying to survive are very attractive and gives them an opportunity to almost slide right into Downtown Press and other printing companies like them. In fact, there are some vignettes that I could send all of you about our inmates. They're like 3 minutes apiece, and their experience and how they have landed in good paying jobs. We have a variety, a plethora, if you will, of different opportunities to learn. One of our most exciting is spatial design, which we train the ladies in the women's prison how to design on a CAD program for capital projects. This is an incredible skill. When released, we have at least 2 of our designers that work for us at headquarters that came out of our system that worked in the
Mr. Son, I appreciate that, and I apologize so much to cut you off, but I don't want to wear on the patience of my committee.
Right.
Is the process by which you evaluate what the market demands are as far as these skills, is that an internal process? Do you work with area business leaders? Is that a board decision? How is that decision came about to make sure that you're providing skills that the market that are in demand for living wage jobs on the outside?
Right. We participate with committees that are made up of outside industry, senators, politicians, people that can weigh in on what we do and make decisions. The management council and the customer council help us make decisions on how we move forward.
Right. And the only other thing, and I would just tell the committee, you testified that it's no cost to taxpayers, but I would offer that MCE has a unique monopoly over procurement in state law, whereby agencies are forced to, by law, to purchase products and goods from MCE before going anywhere else. So even in some of the material that you offer, you pride yourselves in the fact that you could actually get around the minority and women-owned business requirements by MCE. If there's a and so I would say there is a cost. It may not be a direct cost, but because you're mandated in law that you go through MCE, there's definitely a cost to the taxpayers and the small businesses of our state. And I wonder if there's been any evaluation of what the impact on small businesses, especially with an organization that's making $55 million. I could imagine that there are small businesses out here that could really benefit from, and notwithstanding the awesome skills that the agency provide, I would wonder if you guys have done any analysis on what impact it may have on small business. It wasn't identified in the fiscal note.
Well, I'll comment on that by saying this. Recently, we have identified that we could help the Maryland farmers. All right, small business in Maryland, most of them on the Delmarva Peninsula. So we will only buy our chicken products from companies that support and purchase from Maryland farmers. It is our intent to do that wherever possible, including minority businesses. I hope that answers your question. We keep, as best we can, our finger on the pulse of the state. So all chicken quarters that pass through the MCE meat plant, which is one of our largest and best opportunity to be trained. Many of our folks are out there working in all of the butcher shops and ShopRite and Grand Union. Anyway, all the meat that goes through MCE is purchased from only Maryland farmers.
No, and I appreciate that, and I've taken enough of the committee time. I definitely would like to follow up at a later point, but this is definitely an issue that I've delved really into, especially at the denial of that invitation. Thank you so much, Madam Chair.
I'm thinking that maybe during the interim, we need a tour.
I would love it to offer a tour to anyone and everyone that wants to come see. It's been a little difficult because of the pandemic to try to keep our folks safe. But we're hoping that we could resume that. And in place of that, because it's difficult to show who we are, what we do, we created a series of video vignettes. And perhaps
when we come for the tour, we'll see all of that. I want to get to the other witnesses.
Yes, ma'am.
I can't. Okay, who did we stop with? Number 7. All right, Mr. Mark Raleigh.
Good afternoon, Madam Chair and committee chairpersons. My name is Mark Rowley. I am the Chief Administrative Officer here at Maryland Correctional Enterprises. I appreciate and I understand everything that you're trying to accomplish. I'm opposing this bill, and here's why. So MCE is a special fund. Unlike other state agencies that are generally funded, we are a special fund. The comptroller would have to infuse cash, and the Maryland Department of Budget and Management would have to allocate additional funds in our budget to increase inmate pay. So that's my sticking point. But I appreciate everything that you're trying to accomplish. But these funds for this bill would have to come from the general fund. With the money that we have, we pay for raw materials. We have to find men and women who are willing to come inside of a prison and risk their life on a daily basis and pass out tools that could turn into weapons. And unfortunately, in a number of states, that happened. But still, we have a mandate, which is to work with people. Most of the people are medium and maximum security inmates with long sentences, but we don't judge these people. We're working miracles. We're working miracles. The inmates are training and they receive a stipend at the end of the month. This is not really a job, okay? It's created to be an environment because many of these people never had a job before they came to prison. So we're working with them to give them an environment. I appreciate it. I really appreciate everything that you are trying to accomplish. I really do. I'm an African-American and I know about the 13th Amendment and all that, but it costs taxpayers $49,200 a year to incarcerate an individual, $49,200. That's above minimum wage. We have a waiting list of about 1,000 inmates that are trying to get into our program. Mr. Sanders already mentioned our AutoCAD program, but we also have a meat cutting apprenticeship. There's a man who's working at the Whole Food in, I think it's East Harbor in Baltimore. He's the manager of the meat and seafood department who came to our program. So that's one thing. We also have inmates that are working inside the offices. They're learning Microsoft Office. They're learning office management. We have people who are learning a variety of tools and equipment who never worked with tools and equipment. I don't work with tools and equipment. We have forklift training. We have inventory management, which is going to be tremendous. There's a person on one of the videos, I believe he's working for Amazon. He learned inventory management. They snapped him right up. They're learning quality control. They're learning computer basics. But also here's a hidden value that's never calculated is the work ethics that these people are learning, self-esteem. These people have been discarded. We are building them up. We're coaching them. We're mentoring them on a daily basis. We're in their ear on a daily basis, telling them the things that they can do. Communication, time management. These are things that everybody gets when they're in our.
Your time is running out. Let me ask.
Well, let me wrap. Can I wrap this up? Let me just wrap this up. We're different than most correctional industries. Some don't offer monetary incentive, and again, they are earning 4 months off their year. I had the privilege of serving as a board member on the National Correctional Industries Association. And some of the miracles that we have are working here at MCE headquarters. And I took a panel of these people with me to-
So you're really out of time, so you can send us back any additional written testimony.
Okay.
Just ask, what kind of salary do you get for all of this work you're doing?
Well, the salary that I get is published, but I'm making $85,000 a year.
I see.
And we have people who are working here. We had a guy that was working here after he was released. He became an IRS enrolled agent. One of the ladies, our most recent hire, just bought a car in Canton.
Okay, well, but I can't go on.
Okay.
Let me ask colleagues, are there any other questions of this witness?
Yes, ma'am, Madam Chair.
All right, yes, Senator Augustine.
Thank you, Madam Chair. I appreciate that. You know, this is really a troubling hearing. Just in general, I would just say we just want to make sure that we maintain the dignity of all of everyone for certain. You asked a question, Madam Chair, that I wanted to follow up on, which was how much money is in the overhead of MCE. And, you know, as it relates to, because there's such a obviously low labor cost, I mean, artificially low labor costs, how is all this money not showing up, the 30 million that Senator Hayes had been talking about before?
Well, that would be, of course, if we average 2 million hours of training per year, and if the minimum wage was $15 an hour, that'd be $30 million. That's how that number came up. But right off the bat, the inmates are working on raw materials. So that's over 55, that's about 55 cents a dollar. And then we have to pay the men and women who are willing to come inside the institution and to train our inmates. That's about 24 cents for every dollar. Then there's warehousing costs, administrative costs, marketing, design costs, things like that go into the program, but all with the intention of really producing people who are actually able to come out and actually do that.
Let me just say, Senator Peters, who's here representing budget and tax, I hope that given what you're hearing, you might want to go back and have your colleagues on budget and tax really take a serious look, one that might go beyond this period and into the interim, at the entire economic operation there, and at how much can be done under this model for the number of prisoners that we have who need to come out with marketable skills, as well as the slave wages compared to the output and the ultimate annual income being reported in the aggregate for MCE. Okay, I think it has been eye-opening, and we still don't know enough.
Madam Chair, can I have one more question?
Yeah, quick.
With all due fairness to Mr. Rowley, he testified that he opposed Senate Bill 194, and I'm not sure if that's what he meant given the rest of his testimony. I think what his objection is probably to the raise in salary. I wouldn't imagine, given his testimony, that he's objecting to educational services being offered to inmates, courses above a GED level, financial literacy, investing, civics, and that there be reports provided on it. And just as the judge, testified later, the salary is one part of the bill, but there's other things that would not be as costly to the state. And so I know his testimony, and I don't think that he meant to say he disagree or oppose everything in the bill. His big concern was probably just that of the salaries. Is that true, Mr. Rowley?
Yeah, thank you. And I really appreciate that. I really
Thank you
appreciate
so very much.
Madam Chair, I will follow up with B&T. I do sit on the board of MCE. I have taken tours. I've watched what they do. And, I think there's some really good points in the bill, and I will follow back up with you.
Thank you very much. All right. Well, I think that ends the testimony.
Madam Chair, if you would, I don't think one of the questions was answered. Mr. Rowley, could you explain on
Well,
page 23?
to be honest, we're not going to go back at this time. Everybody got the time that we allotted. It was fair. But we would.
I was just thinking for Senator
send
Hayes'
us
benefit.
back
Thank
some written testimony. We'll be willing to share it with everybody.
Yes, ma'am.
That we can make a field trip and come and have you really show us your operation.
Yes, ma'am.
All right, we're going now to Senate Bill 9, Senator Kramer, state employees, collective bargaining, applicability, bargaining, processes, and memorandums of understanding. And we'll hear from Senator Kramer now.
All righty then, Madam Chair, I'm just trying to let everybody have about 2 seconds to clear their heads from the last bill we just heard and sort of shift into an entirely different mode for Senate Bill 9, which committee colleagues, this bill is going to sound familiar. And sadly, that's because it is back before us yet again for another session. This is a common sense bill, period, end of story. As it currently exists, every one of the institutional members of the University of Maryland system negotiates their own contracts for the employees that work in that institution. At least 15 or more contracts. Yet once all those contracts are worked out, or as they're being worked out, they have to go all the way back up the chain to the Board of Regents for approval. And then all the issues work their way back down the chain to be renegotiated or continue those negotiations to then be sent back up the chain to the Board of Regents for their approval. What an absolute waste of taxpayer dollars and tuition dollars. Our students are paying to get an education. What a waste for their money to be negotiating 15 different contracts that have to go back and forth, up and down the chain of command, requiring attorney costs on all sides, requiring bringing in specialists on all sides. It is an absolute waste. And the contracts over 15 institutions There's never a period of time when negotiations aren't happening, and none of this makes any sense. There are 15 different contracts to negotiate the exact same positions. So if you're an electrician in Frostburg and there's a contract going on there, there's another contract in Salisbury or in Baltimore County or in College Park for electricians there doing the exact same job. The exact same job. What is the logic? Where is the common sense? It makes absolutely no sense, and there should be equity. Equity across the board. If you have a job in one part of the system and it's an identical job at the other, why should they not have equality as to economic and non-economic benefits? There is no excuse, there is no reason, there is no logic, there is no rationale. The bill before you provides one contract negotiated with the people who actually make the decision. Currently, across all state agencies here in Maryland, one negotiation, one contract for a far greater number of employees. But somehow the university system is incapable of pulling that off. Ludicrous. This bill provides one contract to be negotiated with the people who make the ultimate decision anyway, the Board of Regents. Otherwise, it just is, to the university system's credit, chaos. It's bureaucracy, and it's unnecessary. And this bill is about streamlining bureaucracy. And anytime we in government can actually pull that off, we're looking like geniuses. Now, the system's going to come in, as they do every year, and tell us that the reason this is done is that it's about autonomy. They want to give autonomy to all of the individual institutions because they're big and grown up and they can make their decisions for themselves. Give them some autonomy. Garbage. There are at least 75 USM policies and procedures right now that are system-wide and come down from the top. No autonomy in those processes. At least 75 policies and procedures that govern everything from soup to nuts, and they are told at each of these institutions, these are the governing policies. There's no autonomy there. There is a system-wide social media policy across the board. No autonomy. There is an 85-page manual, 85-page manual of system-wide procurement policies that every single campus has to follow. So much for giving them autonomy. Somehow, autonomy is important only when it comes to dealing with the hardworking employees of those campuses. They also, and I'm quoting from a system manual, talk about autonomy. Let's look at their spending. institutions with accumulated and uncommitted unrestricted fund balances may request the use of that unrestricted fund balance to pay for a project, first forwarding a request to the chancellor, the vice chancellor of administration and finance, or the board of regents, as spending approval requirements dictate. So even with uncommitted, unrestricted funds, how do they spend them? Got to go to the top to ask permission. So much for autonomy. So the bottom line is, committee, there is no reason not to vote this bill this session, here this year. No more deferring, no more delaying. Let's bring common sense, transparency, equity, cost savings, and respect to university employees by showing them equity and equality in the work that they do. Madam Chair, I thank you and the committee for your time. And we have an outstanding panel that is coming up behind me to further discuss the issue. Thank you, Chair.
Thank you. Before we call on the panel, does any member have any for the sponsor? Okay, we'll go now then to your panel. Okay, the person getting 5 minutes is Patrick Moran of ASME.
Thank you, Madam Chair, Senator Kramer and members of the committee. My name is Patrick Moran, and I'm the president of ASME Council 3. We represent almost 30,000 state and university employees in every legislative district across Maryland, including 6,500 USM or University System of Maryland employees at 9 different campuses. ASME has a single and efficient contract with the state of Maryland where we represent over 20,000 workers in 2 personnel systems in more than 20 state agencies and at over 700 work sites across Maryland. This model is efficient and it works in our far more complex state system. By comparison, our members in the University System of Maryland with 1 personnel system bargain multiple contracts at only 9 campuses, resulting in 15 contracts negotiated for only 6,500 workers. Furthermore, our members are never able to bargain collectively with the entity that creates the policies and the guidelines, and that is the University System of Maryland and the Board of Regents. This legislation allows an employee organization that represents multiple bargaining units on different campuses to bargain one master agreement with the USM. You'll hear from those that are opposed to this bill that it would put the system's accreditation at risk. They will continue to point to the College Park football coach after the tragic death of a student athlete as a result of a hot summer practice. Well, I can put all of your doubts to rest that our members are not football coaches making millions of dollars a year. They are custodians, housekeepers, accountants, and clerical employees, and they deserve a seat at the table with the people that make the decisions, the university system and the Board of Regents. The presidents of the institutions will continue to run the day-to-day operations, just as secretaries in state agencies do with the state. But we have common health and safety guidelines, we have common disciplinary procedures, common work rules, and most importantly, common sense. This legislation allows for local issue agreements such as parking or academic calendars, exactly as we do with the state of Maryland at hundreds of locations. In recent years, the USM has consolidated its operations. Its 10-year strategic plan lays out that it should, and I quote, seek out and pursue at the system-wide level or encourage the institutional development of new opportunities that can streamline or improve services for all USM institutions, such as the development and dissemination of umbrella agreements, intellectual policy waivers, and service-related research opportunities. Excuse me. We have seen the legislature take approaches to create greater synergy within the USM, such as the Empower program between the University of Baltimore and the University of Maryland at College Park. These same themes should be available to workers as well. Our legislation creates greater synergy and allows for an umbrella labor agreement with the USM to work through issues. When the USM was founded in the late 1980s, Governor Schaefer's top aide, David Iannucci, who wrote the law creating the system, he was quoted in the Baltimore Sun, and he stated, "We're all on this boat together." Well, we couldn't agree more. We anticipate this legislation to remedy the concerns we have raised. And with that, we ask for your support of this legislation and for a favorable report. Thank you, Madam Chair.
Thank you. Are there any questions? Okay, seeing none, we're going to the next witness, Selena Singh. Okay.
Very good.
I hope I didn't mess it up today.
Thank you, Charlie. No, you did a really good job. It's not easy. It's hard.
We aren't hearing you well. Can you?
Hi everyone, my name is Selena Singh, and I've been working a little closer. How about now? Is that bad?
Something's.
Can you hear me?
Yes, that's much better.
I'm going to turn my camera off. I just turned my camera off to see if the sound improved.
Well, this does improve the sound.
Okay. I could join my phone, or I could just continue now.
Well, something's happening again. I'm not
Okay,
sure.
I'll continue now. My name is... Okay, great. I'm sorry, I don't have that computer or the Best Buy Wi-Fi. My name is Selena Singh, and I have been working at the University of... Okay, I'm gonna join by phone. I'm gonna try to join by
Okay, let's
phone.
try your phone.
It'll be better.
Okay.
My apologies. I am in the waiting room. Okay, is that better?
I'll tell you what we'll do. We'll go to another witness and we'll come back, and we'll give you some time to try to see if you can get that cleared up. Let's go to John King, Secretary John King, Strong Future America, Future Maryland.
Thanks so much, Madam Chair and members of the committee. My name is John King. I'm testifying today on behalf of Senate Bill 9 in my capacity as former United States Secretary of Education and as founder of Strong Future Maryland, a progressive advocacy organization focused on a just and prosperous future for Maryland. I want to make three points. I know you have our written testimony. One, I want to echo Senator Kramer's important point about the way in which a statewide collective bargaining agreement can reduce bureaucracy and red tape that will make the operations of the university system more efficient. There are many states that have made similar choices. The University of California system, for example, operates in this way. Second point, as you all know, we are going through a national reckoning with issues of racial justice, a long overdue reckoning. One of the things that collective bargaining does is it allows us to address issues of racial and gender inequality. We know there's a long history of employees, particularly at the state's historically Black colleges and universities, receiving inequitable treatment. A common contract will be a way to address that inequity and ensure that folks who are doing the same job across the system have access to the same opportunities and benefits. The third point, when we were discussing this bill on the House side, there was an argument made about accreditation. At the U.S. Education Department, which I ran, we oversee the accreditors. I would point out that accreditors are approving colleges and universities all over the country that have a common statewide contract, including with ASME. I mentioned the University of California system. I'd mentioned Pennsylvania, New York, Rhode Island. In fact, Pennsylvania and New York universities have the same accreditor as University of Maryland College Park, for example. So that's an important distinction as we hear from the opponents of the bill. Ultimately, this is a bill that can improve opportunities for the workforce, address equity, and ensure that we have a fair, safe University of Maryland system for the good, long-term good of the state. Thanks for the opportunity to testify.
Let me ask one quick question. What does it cost the system? Not, we know how the workers are impacted, but what does it even cost the system to carry things from campus to campus and then up the line and then bring it back down the line again in terms of just administrative and other costs?
Madam Chair, Stuart Katzenberg from AFSCME Maryland, the Director of Collective Bargaining. At every campus, there are multiple personnel staff in HR, and oftentimes they hire outside counsel through the Attorney General's office, which costs tens of thousands of dollars per bargaining cycle. And most, some bargaining takes, as the case of College Park, usually 2 years to negotiate, as we found over the last 20 years per contract. Other campuses, half a year or a year, but multiple months. So in terms of time, thousands of hours, and then cost financially, tens of thousands of dollars on the USM side, if not hundreds of thousands of dollars per year when we negotiate.
And in which states did someone just say, you also asked me, is the bargaining agent, was it Pennsylvania, New York, or was it Connecticut?
Yes, Madam Chair. We have a master agreement for the University of California system, which includes research universities and undergraduate universities that covers the whole system, 26,000 employees total, far greater than here in Maryland. We also have master agreements in Connecticut and Rhode Island, and then super master agreements, for lack of a better term, in New York, Pennsylvania, and Hawaii that include state employees and university employees under a mega agreement. And those colleges and universities are all accredited.
Okay.
Madam
All right.
Chair, Madam Chair, Madam Chair.
Yes.
Yeah, my raise hand function's not working good.
Yes, I'm sorry, Senator.
I
Feldman,
did want to
about-
acknowledge, Secretary King, I had the pleasure of meeting him recently, and, we haven't had that many, that matter, residents of Montgomery County serve as the United States Secretary of Education, and I believe it's his first time appearing in front of the State Senate bill hearing or Senate Finance Committee. So I did want to just welcome him and thank you for your testimony, Mr. Secretary.
Thanks so much, Senator. Appreciate it.
Okay, thank you very much. We appreciate your testimony. All right, Senator Reedy.
Yeah, more of just a question that occurs to me in all the talk of streamlining, administrative streamlining, and everybody needing to be equal. Is part of the issue here that it costs a lot more to live in College Park than it does in Frostburg or Cumberland? Because it seems to me that's a reasonable reason why we would have some of these divisions of where why we would have different structures or different bargaining at the different universities. Can someone speak to that?
Sure. Yeah, there are differences, but as you'll find that in the state, we have riders that provide extra income sometimes for people that live in other counties or work in other counties as well. So there's nothing precluding the universities from doing that. I think you'll find, though, that the wages at many of the universities for many of the jobs that we represent are incredibly low and below the living wage. Many of them below $30,000 a year. If you look at, you want to talk about College Park, the housekeepers there, I think, make around $13 an hour, and trying to live on $13 an hour in that area of the state is prohibitive. They can't. It's, you add the amount of time they're taking to get to work from the locations that they live in, that adds to the wear and tear in addition to that.
How would this bill help with that specific issue, or are you just using that as an example?
Well, I'm using that as an example, but I think, what's driving this bill is having common standards. I mean, if you look at what happened during the COVID pandemic, we attempted to negotiate a health and safety standard with the system, and they said, oh, well, this is going to blow over. So don't you think in a couple of months it'll blow over? And we've seen that it did not blow over. And when they said we had to go negotiate these with each and every single university, and when we attempted to do that, College Park refused to negotiate health and safety standards. All of them did, with the exception of one or two. And the only, actually, the one that came out first was Frostburg, which you mentioned earlier. And that's after it blew up at Frostburg, when they were the epicenter of the virus in Garrett County.
Hey, Senator Reedy, I would simply point out that in our state contracts, from one end of the state to the other end of the state, doesn't matter where you live, it's the same contract. And I think trying to figure out and decipher, well, someone may be working in Allegheny, but did they live in Allegheny? So they're paying maybe 50 cents less there for a Big Mac than they would in Montgomery County gets to be challenging, because it could be they're working in Allegheny, but they're living in Washington County, where the difference then is only 10 cents on the cost of that Big Mac. So I think what we're looking, this is all about equity and equality, quite frankly, which we've already acknowledged in state government, across state agencies. Just wanted to point that out.
Okay, let me ask one last question, from me at least. You described initially a system in which you start off with all of the covered employees per campus, and you agree on what the need is, or what's possible, or what's reasonable. And then you're forced to take that from each campus up the line till you end up with the Board of Regents.
Mm-hmm.
And then what happens?
Well, I think a great example of that, Madam Chair, is we negotiated a number of years back an agreement with the University of Maryland, Baltimore. We came to the bargaining table in good faith, and we came to an agreement with management at University of Maryland, Baltimore. And they said, okay, well, you got to send this out to your members for ratification. We did that. And they turned around, shortly thereafter and said, oh, we can't honor this agreement because the system didn't agree to it. They have issues or problems with this agreement. So that led to, almost a 2-year or more process of, not having a signed or agreed to agreement there. I mean, there's a whole list of incidences or examples of this that Mr. Katzenberg can give you that he's experienced as being the chief negotiator at higher ed.
Okay, so after you do you start at the local level with the campus, take it all the way up, then nothing has to happen. There's nothing that forces at some point in time, which you've carried up the line, to be modified if necessary and honored. But then what happens? It comes back down the line again?
Well, that's if the USM agrees to things. Again, they have interjected themselves at every single campus on every single negotiation I think we've ever done.
What kind of cost does that increase for negotiating when you're going up the line and back down the line and back and forth this way?
Well, I mean, it incurs costs because you have the HR directors at every single campus, and then they hire outside attorneys, usually anti-union attorneys that negotiate with them against us. And then that, goes back up to the system where their attorneys and their administrators look at the thing again and give it either a thumbs up or a thumbs down. And then it comes back down again to the table where we reconvene again instead of dealing with the people in authority who are ultimately making the decisions.
Okay, are there any other questions?
Senator Hayes has his
Senator
hand up.
Hayes. Senator Hayes.
I'm sorry, Madam Chair, that was by mistake.
Okay, all right. If no other questions, then let's move on. Where did I stop? Okay. All right, we're going to Lisa Early.
Madam Chair. I thought I was on this panel.
Oh, I'm sorry.
Completed our panel.
You answered a question and we didn't give you testimony.
Yes, ma'am.
I think. All right,
Yes, ma'am.
go ahead.
Thank you.
Thank you. Good afternoon, Madam Chair, members of the committee. Stuart Katzenberg with AFSCME Maryland. I'm the Director of Collective Bargaining and Growth. I've been working for AFSCME for 10 years and have been a party to almost every higher ed negotiation in one capacity or another, including negotiating directly. As my colleagues have said, the system frankly is broken. We find time and time again when I'm at the table, whether it's at UMES, Frostburg, College Park, UMB, when we go over topics, we're told, well, we'll look into that. It sounds good, but we have to talk to the system. And as Senator Kramer discussed earlier, there's actually documents and directives from the university system of Maryland that they oversee, have to and intervene upon collective bargaining between the campuses and AFSCME. During the pandemic, things that are so basic and important to our members, such as health and safety, such as testing, screening, PPE, we went early to the system. They said, go to the campuses. We went to the campuses. They said, we won't negotiate. Not until outbreaks really started in the fall did they finally relent and at least sat at the table with us. As soon as we sat down and gave proposals for more mandatory testing, more rigorous testing, we were told at every campus, no, we're not negotiating that. There's guidance from the USM. That's the only thing we're following. What are we supposed to do there? The USM is telling what our members' health and safety should be, and we can't negotiate with them. What are we supposed to do? PPE, we're following the rules that the USM laid out. Screenings, some campuses are screening very well, others aren't, but we're following USM guidelines. We can do what we want. That's not negotiating. It's a problem. I'd also like to point your attention to sort of the governance documents of the USM and the education article. Most importantly, presidents need to consult with the USM because the USM shall establish general standards, guidelines governing the appointment, compensation, advancement, tenure, and termination of all faculty and administrative personnel in the university system. That's in the education article. Those are our members. We're talking about staff. We're talking about admissions counselors. We're talking about accountants. We're talking about electricians and housekeepers. They do the same job at every campus, and they're being controlled and ruled by the system, not each individual campuses. So as a result, we're sort of chasing our own tail here. Go ahead. Yes, Madam Chair.
So are you representing only classified workers or are you also representing faculty?
No, only classified employees.
Classified employees.
Only
and that's
staff, no faculty.
And it is the case that each of these schools has a separate budget, and in other regards, they reflect the differences and the needs of the particular campus, right?
Yes and no, Madam Chair, as members in Budget and Tax know, and I think many of your members of your committee know, the USM has one budget and then they approve the budgets of each individual campuses and adjust them and the asking of the governor and how they're going to spend their money. So even the budgetary process is controlled by the system. And as Senator Kramer already referenced, part of their budgeting process is to purposely build in a savings every year if they can with each campus called fund balance, whereas they say their budget is $100 million and they purposely only spend $90 million, hypothetically, and they purposely then sock that 10 million away in the fund balance, which is actually controlled by the University System of Maryland. And if I was University of Baltimore and I wanted that $10 million, I have to go to the chancellor to spend it, whether that's on employees or whether that's on new furniture, a new building, new cars for the police department. It's all controlled by the system.
So they really do have a lot less autonomy than other major statewide systems in the states that you cited earlier.
Yes, and that's why this legislation is so important. You know, Senate Bill 9 would bring fairness so that workers have a seat at the table. You know, if we can't talk to the people who are in charge and make agreements with them, because that's what bargaining is, it's coming together, negotiating. We aren't going to get everything we want, but then coming to an agreement in writing. Then what are we doing? You know, this summer, for example, we engaged with the president of the university, the new president of the University of Maryland College Park. Our members were literally getting sick and going to the hospital because it was 100 degrees and they were working in buildings that were 100+ degrees. We demanded to bargain. They said, we'll meet with you. We said, okay. So we through Zoom met, talked about our members going to the hospital, vomiting on campus because they were passing out from heat stroke and they were being forced to work in dangerous conditions. They put in they tried cooling units, they brought them ice, which is all good. And we said, okay, well, let's sign an agreement about what temperature is too dangerous for our members to go in and not pass out. They said, no, we're not doing that. And then, then our discussion ended. There was no settlement. There was no agreement. It was, we hear your people are getting so sick, they're being hospitalized. We appreciate you bringing that to our attention. We'll decide when we let them in and out of the building. That's not negotiating. That's not bargaining.
Okay. I'm learning a lot. I taught for about 30 years at Coppin and I did a PhD at College Park, and it looks like they all messed up. Okay.
Madam Chair, I don't think that Mr. Katzenberg had finished his testimony, and I could be mistaken when you started asking.
But he had 2 minutes. Did we give you 2 minutes?
Can I say, Stuart, did you have additional testimony? Because the chair did start to ask you questions in the process of your testimony.
Yeah, I only have 1 or 2 small points. And then obviously Selena Sarju Singh rejoined us. I would make sure one of our leaders at College Park gets to speak. But the other point is the fiscal note on this is neutral. This isn't a cost to the state of Maryland. In fact, as we sort of noted in US questions, Madam Chair, we think ultimately it will save money where there won't be all these outside of anti-union attorneys being hired by the campuses. And I also want to note that, you know, we think this will save money in the long run for the state, and it will be efficient, and it will give workers the voice that they need to deal with the decision makers who ultimately make the decisions. I have not once been in negotiations where a university president has been present, and almost never has the VP of Finance been present at any of my negotiations in the past 10 years. The deciders aren't there.
Okay. All right, we're going next to Lisa Early.
Madam Chair, can I ask a question?
Yes.
Senator Hayes, and thank you, Madam Chair.
Sure, Senator.
Mr. Katzenberg, I understand. So the testimony, and I hear this bill, it sounds like USM is controlling all this, but like the chair, I'm learning something. I thought that each individual school, but it sounds like you're pretty close to the negotiations. Can you give us some examples of what you described as like the system controlling?
Yeah, sure. Thank you, Senator Hayes. You know, a couple of, you know, besides the examples I've given recently with the pandemic, you know, in the past, we've had negotiations where at Bowie State, for example, a now sort of moot issue around fair share. We were negotiating with Bowie State. I was the negotiator. Management, which included members of Bowie staff and an outside, again, legal contractor, said, okay, your proposal sounds good. We're fine with it. We just have to ask the USM. And then I happened to be present with President Moran the next week in Hagerstown for a separate meeting. And he got a call from Carolyn Skolnick, who I think you'll hear from later today, who called him and said, we're not going to let you have this agreement with Bowie. We don't like the language you're proposing. Our language says that this is how you must conduct business for a fair share election. And we said, Patrick said, President Moran said, your people at Bowie said they would agree to this. You're the USM. I thought people could, you know, bargain for themselves. And the USM said, no, we're not. When I went back to the bargaining table, Bowie State said, sorry, Stuart, we can't agree to this. We were told from the system, there's no way we'll agree to this. So we have to talk about other subjects, or you agree to the way that the USM wants it done. So I don't know what to do in that situation. President Moran also said, I was involved in the UMB ratification a number of years ago, where we made agreements with University of Maryland at Baltimore. Our members ratified the agreement by actually 100% vote ratification. And then we were waiting for the USM just to ratify, like it's perfunctory. Instead, we got a call that our agreement had been rejected after we came to every tentative agreement with everyone on the university side. And we were told the system didn't like that we got too much. And so too bad. You're gonna have to give stuff up.
Let me propose this. I want to go to these 3 unfavorables, then I want to come back to Selena Sagusi, see if she's able to be heard. Okay, so let me go to Lisa Early.
Good afternoon, Chair Kelly and the members of the committee. I am Lisa Early, Chief Human Resources Officer at Coppin State University. I am here to ensure that the record reflects that this bill does not serve the interests of Coppin. Coppin is a much smaller institution than other USM schools. We have a very unique culture and a mission as an HBCU. How we meet the needs of our employees and what we need to fulfill our mission is different than what other institutions may need at any given time. For example, the performance evaluation process is a bargainable issue. And right now, Coppin has embarked on redesigning that process responsive to a climate survey that we conducted. However, this project is not something that's relevant on all the other campuses right now. Another example that we've heard raised today would be the parking rates. The demand for parking on our campus is clearly not what it is for campuses like UMB in downtown Baltimore. So the rates bargained for our employees are much different than they are for other campuses like UMB and College Park. So it's clear that all institutions don't need to bargain the same issues at the same time. So combining bargaining for all institutions just creates more problems than it does solutions. This bill really could conceivably impede Coppin's ability to respond timely to mandates, to be compliant, and to fulfill our mission. Another perspective I'd like to you could consider is that we only have 86 employees at Coppin represented by collective bargaining, and their voice would be silent, be muted if they had to be heard among more than 3,000 College Park employees and 800 UMB employees. I can share with you that recently, when AFSCME petitioned Frostburg and College Park to bargain over health and safety issues, our employees were very adamant that they were happy about the conditions on our campus and that they felt no need to even be involved in the issues on the other campuses. We have very good labor relations on our campus, and the bottom line is we would like to keep it that way. So for those reasons, we're asking that, we'll just state that the USM institutions are not all one size fit all, and I'm asking and urging you to vote unfavorably for this bill.
Let me ask you this. You're happy the way things are and you want to keep it that way, and you don't share the same concerns or system problems that the other campuses share. How much do you share in common with the members of the Board of Regents for the whole system? Do they understand you better than sister institutions would?
Well, I don't know that it's fair to say that they understand us better. I do know that as it is, they do listen to hear what our specific needs are on our campus. And as it is, we do have the buzzword for the day, the autonomy to bring issues to the table and bargain specifically for items that we know serve the best interest of our employees. And I can give you an example. For example, as a Title III, we get federal funding, Title III funding, as an HBCU, and there are stipulations on what we can do with that funding. And training and development is a key part of what we are charged to use the money for. So that in itself is a bargainable issue. And as a result of that, we've been able to implement some unique processes for our employees that enables us to meet the mandates for using the funds, but also ensuring that our employees are receive the best professional development that they can.
Okay, any other questions for this witness?
I have my hand up, Madam.
Senator Kramer.
Thank you for that, Madam Chair. Ms. Early, first, you pointed out that you've got parking circumstances that you believe are different than other member institutions. Are you aware that the bill provides for the opportunity to address just that very issue? And in fact, during the testimony that was being introduced, it specifically was brought out that circumstances such as parking that may be different from one university to another can certainly then be negotiated. What this bill is about is employees and their circumstances. Are you aware that under this bill, the capacity for you to make that negotiation about parking will be unmolested?
I can't say that I am.
All right, may I suggest that you give the bill a thorough reading, and then you will see that I am not misrepresenting that fact. One other quick question, if I may. You said that because of the culture and mission at Coppin, that you should not be part of a negotiation that involves the people at the top making the decisions. But in fact, they do make those decisions. They just let you know whether it's okay or not at the end of the negotiation. So what is it that is in the culture and mission that would perhaps have an electrician at Coppin pay differently than an electrician at Bowie? Could you share that with the committee, please?
I honestly think that the two issues that the question you've raised and the issue you've brought forth toward the end are separate and distinct in terms of what we're really trying to say here. And the process that you described in terms of bargaining is not the process that I know and that I've experienced in my 11 years at Coppin.
Can we get back to the question I asked you? What is it about the culture and mission at Coppin that would mean a custodian or an electrician should have different benefits or wages than a custodian or an electrician at Bowie? Could you please share with me how your culture and mission impacts those circumstances, those benefits in that pay scale?
Well, let me just say this. Generally, I think the negotiations as they are do address, what you're addressing. But I do know when we consider the individual needs of our employees, being able to bargain as an institution helped us to better meet their needs individually. It could be something as simple as an individual needing more uniforms provided. But what's unique and different about our culture is what we look at and what we use to base our bargaining on and what we offer our employees, because they know what they need. And
Ms. Early, it's because they know what they need that their bargaining representatives are here right now telling this committee what they need. And you do not see the employees lined up saying that Ms. Early is giving them what they need. They're here right now saying, we need to go get this done properly. But I thank you for your answer to the question. Very much appreciated. Thank you, Madam Chair.
Okay, we're going to move on to.
Madam Chair, sorry, may I just say something? And I have to respectfully disagree with Senator Kramer because
there was a question, ma'am.
All right, we won't go back and forth. Let her finish.
I can just say that you mentioned that the bargaining representatives were here. I have not seen Mr. Katzenberg or anyone from AFSCME on our campus, I know, in 2 or 3 years. So I just want the record to show that in a sense, our employees are starting to feel like perhaps AFSCME is not really representing them. Thank you.
Okay. Ms. Skolnick. You want to unmute yourself? Can you unmute yourself? Yes.
Yes, Madam Chair. At one point I was unmuted and then the host muted me, so I thought I had been unmuted. Thank you. And good afternoon, Chair Kelly, Vice Chair Feldman, and members of the committee. I'm the Associate Vice Chancellor for Human Resources at the University System of Maryland. And I want to thank you for the opportunity to offer our thoughts. Also wanted to let you know that the University of Maryland College Park intended to provide testimony today, but unfortunately they did not sign up in time. So under current law, it is the president of each public higher ed institution who has the authority to direct collective bargaining negotiations. And it is the governing board that ratifies the resulting contracts. This is the same whether you're talking about Morgan State University, St. Mary's College, or any of the institutions within the University System of Maryland. But this bill would affect a broad transfer of this authority at USM universities only, from the president to the chancellor, effectively to the Board of Regents. And unlike the process described by Senator Kramer, the bill gives the union veto power over designating local matters that would be particular to an institution that could be negotiated directly with the university's president. So it's not accurate that this bill would necessarily allow the institutions to negotiate local issues such as parking. This transfer of authority away from the president will undermine the president's legal role as chief executive officer responsible for the overall performance and day-to-day management of the university. There are also important practical reasons not to take away the president's control of negotiations and replace it with system-controlled collective bargaining. The USM has an independent personnel system that was deliberately not modeled on a typical centralized merit system like the system run by DBM. Presidents are provided with flexibility to set salaries and working conditions to best meet the needs of their institution. As a result, the 12 USM universities have different recruitment, screening and hiring procedures, performance management policies, academic and holiday calendars, work weeks, work schedules, starting pay, pay upon promotion, and shift differential. The university's mission, size, budget, and labor market all influence these decisions. Under centralized collective bargaining that would occur if this bill is passed, how would you decide which universities' practices would be favored and enforced system-wide? Would it be Frostburg State University with only 171 AFSCME employees and a low cost of living and low cost labor market, or the University of Maryland College Park with nearly 4,000 AFSCME employees?
Could I ask you a question just on that point? How is the Board of Regents and the president of the entire system able to make those decisions that you say vary so from campus to campus?
I'm sorry, I missed the beginning of your question.
Ultimately, the way you're working it now, no matter what happens at the local level, it's got to be ratified by the system board.
Yes, Madam Chair, it has to be.
Is that board better able than somebody at your local campus to determine what ultimately the needs are and the reasonable accommodations are as you work through collective bargaining?
Well, the board does have like any governing board, the board has a certain fiduciary responsibility over the institution that they are serving as a governing board for.
But you don't all have the same fees and tuition. I mean, you vary in many, many ways, don't you?
Right, that's right. We vary in many ways. The institutions vary in many ways. And in fact, the ratification process, which was what I believe was being referred to by Mr. Moran when he said they had a contract that the system wouldn't approve. Well, in fact, in my time, since I've been in this position in four and a half years, a little longer, I've seen 30 or more contracts come up to the board for ratification. I'm aware of only one single contract that has not been ratified by the board. So it's really not accurate to say that these contracts come up to the board and then they go back down to the university and they come back up to the board. That is not the process. But
let me ask you this then. What is the value of the time and the energy spent carrying them up and down the line rather than to go ahead and have ratification at the campus level?
If the law says that there's no need for the board to ratify, then that's, that would be permissible, but it is in the law.
That's what we're here considering, isn't it?
Well, but I will say that there's also a requirement that the union's members ratify the contract, and I have seen occasions where the union members decline to ratify a contract that was entered into. Usually it's a sort of a pro forma exercise, and both the Board of Regents ratifies the contracts and the union members ratify, but every once in a while, they don't.
Okay. Well, we're not saying anybody's perfect on any side, but I'm just trying to understand the dynamics and the time. Time is money, and spending the time doing something at the local level, then taking it up the line and then waiting for it to come back down the line all seems like a terrible way to spend the money. Okay, I'm going to let you wind up. All of you guys were supposed to have 2 minutes, and I think we're going over. And then I'll go to the next person.
Sure, then I'll just be brief and say that if consolidated bargaining is required under this bill, it will result in competition between the universities with perceived winners and losers, which will not be good for employees. So for these reasons and the reasons stated in our written testimony, we would urge a favorable report. Thank you.
Okay, we're going to Don Rhodes, and then we'll come back up and try to see if we got the
Madam Chair,
problems worked out. Yeah,
I'd be happy to come back to ask some questions of Ms. Skolnick if you prefer later on, or may I ask them now?
well, go ahead.
Thank you, Madam Chair. Ms. Skolnick, you're basing your assertion on the reason why there should be this separation because things are just very different at various campuses and it's just a very different world. Can you share with me what the difference would be having an electrician at the University of Maryland, Baltimore County, replacing a burned out compressor motor on an HVAC unit there on Baltimore campus from that of an electrical work replacing a burned out motor on an HVAC component in Salisbury. Can you share with me what the difference there would be? Or even feel free to throw in Coppin State, since they evidently have something else that's different going on there per Ms. Early's comments. Would you share with the committee the differences, please?
Sure. Some of the differences relate to whether or not the institution performs as a Research One institution, as the University of Maryland, Baltimore does. The job requirements of an electrician might be quite different than compared to the.
I didn't ask
Excuse me, I'm sorry, I wasn't finished.
I asked a simple question.
Okay.
A compressor motor in an HVAC system.
Sure.
Okay.
Would you like me to answer the question or? Okay. So I apologize because I'm not an electrician myself, and I'm not even sure exactly what a compressor motor is. If both of them are changing a compressor motor, or then maybe that part of the job is the same, but the remainder of the job may not be the same. But more importantly, there are different labor markets. I can tell you that College Park has a lot of trouble being able to hire qualified HVAC mechanics because
You're
the
not
labor
answering
market
my
is
question,
very
Ms.
different.
Skolnick. Ms. Skolnick, come on, please. I asked you a very simple question and clearly you're avoiding answering it. I'll even simplify it. Since you don't know what a compressor motor is, not that that has anything to do with answering the question. If there is a custodian mopping up spilled milkshake on a cafeteria floor at Towson, can you explain to me how all the subtle variations between the institutions in the system would make it different for a custodian cleaning up spilled milkshake in the cafeteria at Salisbury? And I don't think that will challenge your skills and know-how.
Well,
Come on, let's go with this.
Is that fair?
Sure. Madam Chair, would you like me to answer the question? I wasn't sure if.
Sure. It's an easy
Okay.
question.
So what I can give you as an example is you might have at one university, you might have a compressed work schedule where custodians or housekeepers are required to come on board at or report to work at 3 o'clock in the morning and work a 12-hour shift. That, as opposed to at another university where they may be working regular 8-hour shifts, that might be a reason that you would see different levels of pay negotiated for those positions.
And you're saying the Board of Trustees can't figure that out across the board?
Those issues are locally controlled at the universities.
Okay, thank you.
Okay. All right, let's go to, who were we trying to call on? Was it Dawn Rhodes? Did she get a chance?
Good afternoon, Chair Kelly and Vice Chair Feldman and other members of the Finance Committee. Thank you for allowing me the opportunity to testify today. As you said, I'm Dawn Rhodes, Vice President for Administration and Finance at the University of Maryland, Baltimore. The majority of UMB's AFSCME employees are in my division. I would ask that we all keep in mind that we are not discussing what is in the best, that we are all discussing what is in the best interest of people, not union members, which is why UMB does not support SB 9. These individuals are our employees and we care deeply for them. I started at UMB in August 2017. In August 2018, I conducted focus groups with nearly 30% of our custodians. I did the same in 2019 with 60% of the facilities and operations staff. As a result of the conversation with our custodians, UMB raised the minimum hourly rate to $12.91 from $12.06. This increase was made retroactive to July the same year and paid from UMB's existing funds. 154 AFSCME employees received higher wages because we listened to what they said to us. Under the proposed bill, I can't even comprehend how we would be able to implement a 7% increase in the hourly wage rate for our employees. Our sister institutions with fewer resources than UMB surely would find it problematic if we were all required to act in lockstep. I'm equally concerned to have UMB's employees combined with College Park's union members that number 3,300 compared to our 800. In a union negotiation, they would literally be the two-ton gorilla in the room, potentially dwarfing the needs of others. College Park is in a higher wage market than us in Baltimore. I fear being forced to fund wages higher than our Baltimore market would necessitate. This would cause us to increase all wages and salaries to avoid wage compression issues. I'm trying hard to understand the rationale for paying employees the same when the cost of living is very different between areas like, say, College Park and Frostburg. Forcing salary alignment across geographic areas with different costs of living is in fact ignoring our fiduciary responsibilities. There is absolutely a cost to this bill. I have a last point that I hope is not lost on anyone. Over 90% of UMB's custodians are people of color. 90 out of 94 of UMB's security guards are African American or Latinx. Nearly 18% of UMB's facilities and operations employees are people of color. Their voices are finally being heard. This proposed bill could silence them again. I would ask that the consideration of this bill be done through a lens of diversity, equity, and inclusion. I again respectfully register UMB's lack of support for SB 9. Thank you.
Okay. Are there other questions for this? Well, questions for this witness?
Just wanted to see if we can get Selena back up, Madam Chair.
Well, I'd like to go back to the witness that we tried to hear earlier to see if she can.
That's what I'm talking about.
Okay. All right. And so that was Selena Saguchi.
Yes, thank you, Madam Chair. I hope this is better.
Yes, this is.
All right, I apologize. I don't have the best Wi-Fi or the best laptop, but thank you for being patient with me today. My name is
only have
Selena.
2 minutes, so.
Okay, I'm going. My name is Selena Sarju Singh, and I've been working at the University of Maryland Health Center for 9 years. All that time, I've had to work multiple jobs in addition to my job at UMD to make ends meet. As a woman of color, our union has been vital for me and my coworkers to have greater voice at work. I love my job at the health center. I love the university, the students, and the school. I have 2 kids, Novea and Mateo, and I do hope that one day they can be proud Terrapins. As much as I love my job, however, I am disheartened by the attempts of my administration and the USM to prevent workers from having a strong voice at work. Time and time again, the health and safety of our members is treated as unimportant. At UMD, we attempted to speak up and raise concerns about the mold crisis, which sickened many of our members only to be rebuffed. During the pandemic, UMD has refused to bargain health and safety with us, despite the fact that hundreds of our members have gotten COVID and hundreds more are working directly in the quarantine and isolation facilities or facilitating testing through my health center. The issues of health and safety aren't unique to UMD. Our fellow union members at Frostburg State saw their administration refuse to bargain with us until the COVID outbreak overwhelmed the university. Even now, they have not come to an agreement with us to ensure the campus is safe. All of our campuses voted to have a union, and the union members on those campuses do support this bill. We need one set of mutually agreed upon rules that protect every worker and ensure we are under the same contract. That is why we need the Maryland General Assembly to support SB 9, HB 486, so that workers can band together and have the ability to bargain with the USM directly for a fair contract. Thank you for your time.
Thank you. Are there
Senator
questions?
Kelly, this is
Yes.
Dawn Rhodes. Can I answer the question
well-
that Senator Kramer didn't ask me?
No, you can't at this point, but we would accept any further feedback that anybody would like to send you. If you send it to me, I'll see that everybody gets it, or you can send it individually. And we do appreciate your trying to still answer the question. Okay, what were we doing?
I think we're done.
Okay. Okay. We had no other questions of the last witness, right? Okay. All right, Senator, I think that ends the testimony on Senate Bill 9. And we appreciate everybody who has come today to share your perspective on the bill.
Thank you, Madam Chair.
Thank you, Madam.
Okay. Members of Finance, we will have the abbreviated voting session tomorrow at 11 for about 45 minutes before we go to the floor. So we can be here on time for that. We'd appreciate it. Okay. Okay.
Madam Chair, no voting today. Is that correct?
That's right. No, not today.
Okay, good, because I thought we did. Thank you.
Okay.
Oh, Madam Chair, before we quit, I would be remiss of me if I didn't mention you have Senator Feldman's very happy birthday today. So I wanted
That's right. Happy
a very
birthday.
happy birthday.
Thank you so much, Senator Kramer.
I'd be happy to sing.
No,
No,
not
hey,
necessary.
please, no, spare us.
Not enough.
No, that's enough. We're good.
Spare us.
I move that we adjourn this meeting on that note.
Happy birthday.
Happy birthday.
Birthday,